Thank you so much. I'm going to call the Assembly Committee on Judiciary to order this morning. Could our secretary please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner. Assemblywoman Marzola.
Here.
Assemblyman Miller. Assemblywoman Nguyen. Assemblyman O'Neill.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. I will note for the record that Assemblyman Miller is with us. It looked like he didn't unmute quick enough, and we also have Vice Chair Nguyen with us as well. So if you could please mark them present. I think that just leaves Assemblywoman Krasner, who's not on yet. So please mark her absent for the time being, and then I will try to note when she arrives in the meeting. Good morning to members of the Judiciary Committee, and good morning to members of the public who may be watching today on the legislature's website or on our YouTube channel. Welcome to day 36 of the 81st session of the Nevada Legislature. Just a few housekeeping matters before we get started. Folks on the Zoom with us, could you please be sure to mute unless you are speaking? That'll help with the feedback. For our presenters today, if you could please remember to state your name each time before you speak, particularly when you're asked a question. That'll help our committee secretaries prepare the minutes. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy. That's perfectly okay, but we need to make sure we're being respectful of one another and of the legislative institution as well as staff. And then last, many members are using multiple devices to access this meeting: laptops, desktops, iPads, phones. So please don't see it as a sign of disrespect if members appear to be looking away at other devices during the meeting, most likely trying to look at exhibits or other notes to help us participate in this virtual meeting. So with those housekeeping matters behind us, we're going to move on to our agenda. Members, as you can see, we have two bills on the agenda today. We are going to take them in reverse order at the request of our first presenter. So at this time, I'm going to open the hearing on Assembly Bill 132. Assembly Bill 132 revises provisions governing juvenile justice. Members, you should have received an email sometime yesterday with an amendment that is being proposed by the sponsor of the bill on Assembly Bill 132. And members of the public, you'll find that on Nellis as well. So please be sure to reference that when we're going through the bill. I think that'll help further the discussion. And then I want to welcome to the Assembly Judiciary Committee, I think for the first time this session, Assemblyman Flores, who is no stranger to this committee. And I believe he has another presenter with him, Ms. Olivares as well. So we'll give you two a chance to present Assembly Bill 132, and then I'm sure we'll have some questions. So welcome again, Assemblyman Flores, and the floor is yours when you're ready.
Thank you. I'm just checking my audio. I want to make sure that I am unmuted, Mr. Chairman.
We can hear you.
Perfect. Thank you. Good morning, Mr. Chairman, Chairman Yeager, Vice Chair Nguyen, esteemed colleagues of the Judiciary Committee. I am Assemblyman Edgar Flores here in the great state of Nevada, proudly representing Assembly District 28. And today I have the great honor of presenting Assembly Bill 132 on behalf of every youth in this state. I wanted to briefly offer a roadmap of how I intend to proceed with the conversation this morning, as I believe it will be helpful to follow along with the discourse. And I also wanted to allow myself a little bit later during my presentation to introduce my co-presenter, Dr. Ana Olivares, who is a gem in this community and does amazing work. And I think you will find her co-presenting will be incredibly helpful to further unravel why I believe this bill today is necessary. The way I intend to proceed with the conversation is as follows. I'd like to first walk you through, in a very brief but detailed manner, how the landmark Miranda versus Arizona, a 1966 Supreme Court case, laid the foundation for how procedurally across the country, and particularly in the state of Nevada, we now have to read Miranda warnings prior to a custodial interrogation occurring, and what the importance of that is. Afterwards, I'd like to go into concerns that I have with the Miranda warnings, particularly when it comes to our youth, that is, individuals who are 17 years of age and under. Next, I'd like to hand over the presentation to Dr. Ana Olivares, who will be able to provide insight as to some of those concerns, how the science demonstrates that there should be concerns that we as a state should collectively try to address. I will then ask for the presentation to come back to me, and I will walk you through the conceptual amendment that I hope everybody now has a copy of, explain to you the genesis of the original language, why the conceptual amendment is here, explain how I believe that conceptual amendment addresses those concerns. And then lastly, I'd like to preemptively address some of the opposition that we'll be having this morning. I'll walk you through some of the concerns they will raise and how I believe this bill far exceeds those concerns. And then lastly, I would open it up for questions. Again, I want to thank Chairman Yeager for allowing me the opportunity to be here today. And if I could start with the landmark case of Miranda versus Arizona. This is a 1966 case. I am emphasizing 1966 because there is the ability for us as a society to forget how recent a lot of these things are. And we have a tendency to believe that, well, we've always had these constitutional protections. They've been there since the very start of our democracy. Our country has consistently enforced them. What more can we do? This is a 1966 case. And in the Miranda v. Arizona landmark case, if I could just offer a quick synopsis, that is the case that now requires, before a custodial interrogation to occur, the very famous phrases that we hear when you're watching a reality TV show or when you're watching a movie, the very famous Miranda warnings of you have a right to remain silent. Anything you do and say can and will be used against you in a court of law. You have a right to an attorney. If you can't afford one, one will be afforded to you. Now, we always hear these phrases and we take them for granted. But they are incredibly important because prior to 1966, and if you read the landmark case of Miranda v. Arizona, should you want to geek out for a bit, you'll be given the opportunity to understand what was happening. Prior to 1966, and if you read that particular case, you'll hear a case of an individual who on multiple occasions asked for an attorney to be present during interrogation and was denied the opportunity to do that. You'll read about how factually, while he requested to not continue for the interrogation to continue, was forced to stand, and it went on for hours upon hours. The Supreme Court engaged in a very scholarly argument where both stakeholders from both sides entertained the argument of, are we protecting and providing every individual their constitutional protections afforded to them when we don't have a set of instructions and procedures that we're following nationwide? And the ultimate consensus was no. And now there is a whole body of scholarship that explains how important this is. But if I can, one of the key things in that Supreme Court case that often, in my opinion, gets slightly overlooked because we focus so deeply on the right to remain silent, the right to an attorney, is the language that they use. And specifically, I'd like to quote and read directly from that. It says, the defendant may waive effectuation of these rights, provided that the waiver is made voluntarily, knowingly, and intelligently. Those three words are key because a Miranda warning means nothing if you don't understand that when you waive them away, you're doing it voluntarily, more importantly, knowingly and intelligently. This is where this bill comes into play. Assembly Bill 132 seeks to address the disparity and disproportional realities that exist between adults and minors. Now, there is a whole body of science that is undisputed in scholarly journals and law review journals that discuss this particular matter. There is now science that talks about that the brain development does not end somehow magically at 18 or at 21. In fact, the science goes far into the late 20s. And I mention that because then it begs the question that we as a society have to answer is, are we, when a child under the age of 17 or under, are they voluntarily, knowingly, and intelligently waiving those protected constitutional rights that we so fondly hold true to this country? And it is my response that the answer is no. I have always anecdotally said that when we talk about the Olympics of who is the most disproportionate when it comes to access to the courts in this country, and I've engaged in conversations about how potentially it could be disproportionately impacted communities, our Black community, our immigrant, migrant communities, LGBTIQ communities. But I've always consistently have argued that it's minors. Kids are born in a systemic system, in a systemic structure, better said, where you have to listen to adults, where you don't recognize that you have constitutional protections that are afforded to you. You listen to your parents, you listen to your teachers, you listen to authority. At no point, and very seldom does a child ever genuinely recognize the power of saying no, the power of recognizing that they can remain silent, that they have a right to an attorney. These things are foreign concepts to them. And that's where this bill is so instrumental. If I could walk you through just a set of examples that I think will help explain why I think this bill is so important. When we think of our youth, here are things a 17-year-old or under cannot do and or is limited in one way or another in doing. Entering into a binding contract, buy or selling property, including real estate stocks, the ability to marry without parental consent, depending on their age, sue or be sued under their own name, compromise, settle, or arbitrate a claim, make or revoke a will, inherit property, vote in a national, state, or local election, consent to all forms of medical treatment, join the military, purchase and consume alcohol, gamble, purchase and consume tobacco products, work, get a driver's license, even watching an R-rated film. I can go on listing a whole host of things that we limit our minors from doing. And yet somehow we have a tremendous amount of pushback when we talk about ensuring that we're giving them the right to their constitutional rights. It is so incredibly important that I make this point. I think that, and I wholeheartedly believe this, that we as a society have the desire and consensus to limit in so many ways what a child can do, because we as a society want to protect minors. We don't do it because we're trying to help adults. I genuinely believe that when we implement all these different parameters of protections and layers of what we're going to do to ensure that what minors can and cannot do, it is to, because as a society, we agree, we have a responsibility and obligation to protect them, because we realize that the child is not there at that maturity level. And so I want to make sure that through this bill, we take into account those realities. In fact, I've provided, and I'm not going to go into that exhibit, but I provided as an exhibit. And if you see that exhibit, there's a slideshow from Kings County, Washington, that talks about why there is a disproportionality in understanding, a lack of ability of understanding, and why the law is different when it comes to an adult and a child. And I implore you to look at it briefly later, just so that it could help put into perspective some of us that may be visual learners and like to see things. I think that slideshow does a good job of that. But namely, in the last 25 years, and you'll see those cases highlighted in that slideshow, there's a body of Supreme Court cases that specifically delineate and capture this societal understanding that minors are inherently different to adults, that minors grasp things differently, that minors are incapable of understanding that a decision today may have long-lasting impacts on their life, that the science, and that there's a consensus in the science that a child's mind is not the same as an adult's. If I could further delineate that by handing over the presentation briefly to my co-presenter, Dr. Ana Olivares, and then after she does her presentation, I'll bring it back and talk about how I believe this bill addresses the concerns that Dr. Ana Olivares and that I presently put on the table. But before I do that, I just want you to get a perspective, because Dr. Olivares is not one to highlight or throw around her resume. I just want to briefly read you her quick bio. Dr. Ana Olivares is a licensed clinical psychologist in the state of Nevada. She earned a master's degree in child and adolescent psychology and a doctorate degree in clinical psychology. She is trained in the evaluation and treatment of mental disorders. Dr. Olivares' training history includes personality intelligence testing, psychotherapy, diagnostic evaluations. She has trained and worked in various settings throughout Las Vegas, including in patient psychiatric facilities, outpatient clinics, and most recently in her own private practice. Dr. Olivares served as a Southern Board Secretary of the Nevada Psychological Association and as an adjunct faculty for the Graduate Medical Education Residency Program at the Southern Hills Hospital. If I could now hand over the presentation so that we can get further into the science of the brain development of a minor. Dr. Olivares, please.
Good morning. Thank you for that introduction. So I'm here to talk about brain development in adolescence, and I'll use adolescents and young people interchangeably. So the impact of, and also on the impact of stress on judgment and decision making. So I'd like to talk about what this looks like for young people in particular. So we're focusing on the dynamics of a high stress situation and the underdeveloped brain. Generally speaking, being able to cope with stressful situations is an important part of healthy brain development. And the larger evidence does support that our brains continue to develop throughout adolescence and for most of us well into our mid-20s. That being said, a young person's decision-making and judgment could be especially impacted during an intense situation, such as an interrogation or an interview setting, especially without a parent present. Being able to make sound decisions during high stress situations is in and of itself beneficial for us because stress is a part of life, right? So having that skill is essential. This process does happen very differently for an adolescent brain, and it comes down to more than just an adolescent lacking experience or intelligence. So this in part is why we commonly see adolescents engage in behaviors that are impulsive or dangerous at times. The way they think, the way they solve problems and interpret social cues, make decisions is very different than the way adults do, for most of us. It doesn't mean that they're not able to make sound decisions or make good decisions or know right from wrong or understand consequences, but they are more guided by the reactive and emotional part of the brain rather than the logical frontal part of the brain, which controls motivation, goal-directed behaviors, problem solving, and impulse control. That is because our brain matures from the back to front, essentially, right? So when we're adolescents, it's not fully developed, and those connections that adults have are not made for young people. How we respond to stress and what happens to our judgment and decision-making abilities depends on factors such as our perception of stress in the moment, external conditions. So our environment has a lot of influence on our judgment and decision-making. And again, access to critical people who play critical roles in our lives, such as a parent or another support person. Having access to a person who plays a supportive role acts as a buffer. So it helps to mitigate those emotional reactions during intense situations. Now, generally speaking, what happens when we're in a high stress situation or a dangerous or threatening environment, our brain perceives an environment with that kind of intensity and it goes into like survival mode. So there's physiological and cognitive processes that happen within milliseconds. So the way I'm talking about it is very kind of in a process, but for everyone, it happens very, very quickly. So we don't even notice it really. So the demand on our body and our brain systems to immediately cope with these situations and still be able to make rational, reasonable decisions is hard when we're in an intense environment. So during this process, when we're in survival mode, our sympathetic nervous system is activated, and this signals hormones to act, right? So this is why we experience, again, for all of us, we experience intense heart rate, our blood pressure goes up, we have rapid breathing, we get an adrenaline rush, and then that also signals other hormones to go into production, like cortisol, which I think most of us know as the stress hormone. Because our stress response is activated, we're not fully able to tap into the brain function that thinks clearly and logically. The brain function that's able to evaluate a situation, evaluate consequences. And so things like our insight and judgment and our memory can be compromised during these high intense situations. We also experience changes in emotion and behavior. So this is when we get nervous or our voice gets shaky, might have nail biting or being fidgety. Again, this all happens very, very quickly within moments of exposure to a high intense situation. Cognitively, so our cognition and our thinking process is also impaired, or it can be impacted. So our ability to focus becomes foggy. Our thinking can become unclear, and it can very easily be very hard to articulate ourselves and articulate our emotions or understand what's going on. In the context, in particular, I think in the context of this bill, I guess, in the situation, an adolescent in an interview setting that is fidgety and is confused and it doesn't know what to say. I think, the implication of that is that it can be perceived by someone as being insincere or deceitful. So there is mixed research on the role of age in decision making. What we do know is that the adolescent brain is fundamentally different than older brains. And this basic difference impacts how they execute their decisions. The way they weigh their pros and cons is different. For example, they tend to overestimate the rewards of a decision and don't accurately assess risks. The context and how an adolescent understands the situation is also important to consider. For example, in my world, like in psychotherapy world, an adolescent can provide assent, which means that you can talk to them about, the treatment and get their assent to participate in treatment as an adolescent, but they can't fully understand. They can't fully consent to treatment, without a parent or a guardian. And the reason for this is essentially to protect the adolescent from making a voluntary decision without weighing the alternatives. Now, moving on kind of from the brain functions and what happens when we're in a high intense situation, there's other factors that influence the way adolescents or young people make decisions. Social factors have a really big impact in their decision making. So to the tune of what Assemblyman Flores said, expectations of obedience to authority figures, right? This very highly influences a young person's decision making, saying something that they think an authority figure wants to hear. Again, when we're in this fight or flight response, we just want to get out of the situation. And so that can influence the things that we say. What we think that we should do. Okay, the understanding of language. So this has a big impact because of the differences in demographics and socioeconomic status, and the groups of adolescents and young people that come in contact with law enforcement or end up in an interrogation or an interview setting. Another factor is the actual access to legal resources. And again, the individual vulnerability to suggestive language is also something that can influence and impact that for a young person. To sum things up, from a clinical perspective, the decision-making process is impacted by biological and situational factors and the course of brain development. Again, while we want adolescents to have autonomy in making decisions and be able to guide and their decision making. The larger body of the research and what we see in juvenile studies suggests that because their brain is not fully developed, adolescents are more likely to make decisions based on impulsivity and emotion rather than logic and true understanding of an entire situation. And that's all I have.
Thank you, Ana Olivares. And this is Assemblyman Edgar Flores for the record. Esteemed colleagues, at this time, what I'd like to do is walk you through the actual bill. And I wanted to first lay the foundation and really give context to what we were talking about here, because it's difficult to engage in this conversation without first understanding where the science says the mind of a child is, to further elaborate on the importance of this.
And welcome back to my channel.
Excuse me? My apologies. I thought somebody was asking a question. If I could walk you through a hypothetical to put into context that we could work off of, and then use that to the actual language. I'm gonna be going directly off of the amendment, the conceptual amendment that I provided to you. So for the sake of simplifying it and not getting too complex into a lot of legal argument, let's say there is a minor, age 15, and law enforcement, through the course of their investigative work, makes an arrest in the good faith belief that a crime has been committed and that the individual being arrested committed that alleged crime. Everything that happened prior to that, everything that happened prior to the member of law enforcement formulating that thought process to where they got to their probable cause, is irrelevant to this case, to this bill, excuse me. We are in no way changing the tactics law enforcement do for their investigative coursework. We are not in any way changing the way they enter into dialogue with folk. Understandably, you all know that law enforcement often start just an investigation because they want to figure out what's going on and start to dialogue with humans continuously, do that all the time. And at no point does an individual have to engage. They can walk away from that conversation. We're not talking about that here. We're talking about after that probable cause has been formed. That young man or woman has now been placed in handcuffs, and they start to read her or him their Miranda rights. You have a right to remain silent. Anything you do or say can and will be used against court of law. If you don't have an attorney, one shall be appointed, et cetera, et cetera. That's when a custodial interrogation triggers. And that's where this bill commences. So if I can, I'm looking at my conceptual amendment and looking at amendment number 1, which reads amend section 1, lines 2 through 12 of my original Assembly Bill 132. When I first presented or submitted the request for Assembly Bill 132, I submitted it in the spirit of trying to work amicably and starting with what I thought was a middle ground from a previous bill presented in 2019, Senate Bill 535. So I thought that was kind of the middle ground where folk had landed, and I wanted to grab that language and continue off of that. But after having an opportunity to have spoken to all the opposition, I realized that in fact wasn't true and that it wasn't a middle ground at all. So I decided to completely move myself away from that narrowly tailored language and instead present this. If you're curious as to why I started in one place and moved to this conceptual amendment, that's the only reason. So what that reads is as follows: except as otherwise provided in subsection 2, a peace officer or probation officer who takes a child into custody shall make an electronic recording of any custodial interrogation of a child if alleged to have committed any act deemed to be a felony or an act deemed to be a gross misdemeanor. So what I'm doing here is I am saying that if there is a 17-year-old or younger, 17-year-old or younger, who has now been read their Miranda rights, and it is alleged that they have committed a felony or gross misdemeanor, that they have to follow a set of rules after that. And I'll get into those rules in a second, but I want to first delineate what's happening here. The reason I'm doing this here is you'll notice that it doesn't include misdemeanor. There's a whole host of reasons why I didn't include misdemeanor there. One, I did it in the spirit of compromise. I recognize that there is a whole host of opposition, some of which will talk about fiscal impacts and concerns. And so I wanted to, in the spirit of reaching an amicable middle ground, not to say that they will support it by me doing this, but trying to minimize that impact. I did it for that reason. I also did it because, understandably, a gross misdemeanor and a felony can have long-lasting impacts in the life of a child that can impact their employment in the future, their liberty to a great severe length, can have detrimental consequences that, should they engage in waving away of rights that they don't understand they're doing, could impact them for the rest of their lives. So that's why I'm focusing specifically on felonies and gross misdemeanors. Amendment number 2 says, if the language in section 1 is true, in other words, that a 17-year-old or younger has now been arrested and has been read her or his Miranda rights and is alleged to have committed a felony or gross misdemeanor, then prior to a custodial interrogation and before the waiver of any Miranda rights, a youth 17 years of age or younger shall consult with legal counsel in person, by telephone, or video conference, and the consultation may not be waived. So this goes back to everything Dr. Olivares indicated and everything I prefaced in the opening remarks of this presentation. That key case of Miranda versus Arizona was so instrumental because it talked about ensuring that folk understood their protections, their rights before they waved them away, but that language that they needed to do it willingly and intelligently often gets ignored. And it is my position that because minors, and it is supported by everything else we limit minors in doing. We don't let minors do a whole host of things, and yet we're allowing them to willingly, and I say willingly in quotation marks, wave away their protections. And it is my belief that they don't do it knowingly and intelligently. And so what I want to make sure is that before they right after they're read their Miranda rights, but before they waive their right to remain silent, before they waive the right to an attorney, before they stop a custodial interrogation in the middle of it if they don't feel comfortable answering any more questions, before they do any of that, that they first have to have the right to consult with an attorney. And the way we see this playing out, and we see it playing out in other states, is there is a on-duty telephone number that is set up. And after the probable cause is established, the minor is now arrested, the Miranda rights are waived, you would then give a phone to that child, right? And give them the option to speak to an attorney, where the attorney could then consult and explain to the child in a different way, in a whole host of different, using a whole host of different words, whether or not it's to their advantage to waive away these rights. And it will then be up to that child whether or not they want to do that. Now, they still decide to waive away their rights after all that has occurred. Then at that point, the custodial interrogation can continue. But otherwise, an attorney must be present should the child decide for that to be the case. The third thing in this amendment that was not in any way contemplated in the original language, but is equally as important in this dialogue, is that I want to create a modified Miranda warning that does not, and it is very important to make this point. The Supreme Court case laid the floor, the bare minimum that we must do to ensure that before somebody waives away their rights, They must be read a set of phrases, and that they have to intelligently and voluntarily waive those before before the custodial interrogation can occur without an attorney or whatever it may be. They laid the floor, not the ceiling. We as a state can collectively say, that's the bare minimum, but because we understand that there is a whole host of Supreme Court cases that talk about that minors are different from adults, that they don't understand and grasp the gravity of things in the same way adults do. We want to make sure that we expand the way we explain Miranda rights in a more simpler way, so that that minor has a much better understanding what's happening. By no means do I suggest that this language is perfect, that this modified Miranda will be the end-all, fix-all for minors in juvenile justice. But what I am saying is it will be much better than quickly reading to a minor, you have the right to remain silent. Anything you do or say will be used against you in court of law. I think this could help that in a much more impactful way. So here's a suggested language that is borrowed and currently used in Kings County, Washington. And by the way, I want to thank two students, Abril and Alessandro, who were instrumental in helping me with some of this research. And I wanted to do a shout out to their students from down south and up north. And I just wanted to say thank you to them. So as I walk you through this, I'll explain to you the importance of it. So one, you have the right to remain silent, which is what we do now, right? Law enforcement is doing this now. But then it's followed by, which means you don't have to say anything. It's okay if you don't want to talk to me. And then number three, it's a reminder that anything that is said can and will be used against him in a court of law. If you want to talk to me, I can tell the juvenile court judge or adult court judge and probation officer what you tell me. It's a reminder that whatever they say can be held against them. Number four, you have the right to talk to a free lawyer right now. The free lawyer works for you and is available at any time, even late at night. The lawyer does not tell anyone what you tell them. The free lawyer helps you decide if it's a good idea to answer questions. The free lawyer can be with you if you want to talk with me. Here, we think that everybody just automatically assumes that there is this thing called attorney-client privilege, rules of responsibility. But what we're doing here is ensuring in a simplified way that the child understands that communication is sacred and that nobody has a right to understand or hear or know what they said to that attorney. Number five, if you start to answer my questions, you can change your mind and stop at any time. I won't ask you any more questions. Again, this is reminding the child that even if you waive your right at the beginning, at any time after, you can stop and say, you know what, I no longer feel comfortable. Number six, a very important question is, do you understand? And even if the child says, yes, I do understand. And even after number seven, do you want to talk to me? Number eight is key, because even after all that happens, then the member of law enforcement will tell them, understood, and specifically read, I will now let you speak to a free lawyer before you answer any more of my questions. This is key to ensuring that we as a society who recognize key differences between minors and adults, that we're following everything about that as a consensus as a society, but more importantly, as what we're seeing that the case law and Supreme Court cases are moving towards. Now, very briefly, I want to go between what the opposition will likely discuss. And one of the things you'll hear the opposition say is, in the modified Miranda warning, we should have the opportunity for a parent to waive away Miranda rights. And so what they would like to see is that there's a language in there that says you have a right to speak with your parents, or your parents can be present, and then that the parents can waive away those rights. Now, I don't know about you, but when I was a kid, the worst thing you could tell me was, I'm going to call your mom. The worst thing you can tell me is, I'm going to call your dad. I was terrified, even when I didn't do anything wrong. It was the most terrifying thing you can tell me. Even if I'm not scared of my parents. My parents are caring and loving humans, but they're not lawyers. They don't understand what protections are afforded to you. They may be in a very difficult situation financially where they have to get back to work. And rather than advocating for the kid, they'll serve as somebody who's there. You better tell them now. I know you did it. I don't got time for this. They could end up hurting the minor. unintentionally at times, it could be a problem rather than something helping the child. I think it could be more of a burden. Another thing you may hear the opposition talk about is that if we modify the Miranda rights, are we somehow going to put ourselves in a constitutional area that may infringe on the individual's rights because Miranda v. Arizona 1966 laid a parameter of what we have to do. And I want to remind you that, first of all, in the state of Nevada, we already have a modified Miranda rights that are read to kids in some of our school districts. On top of that, this modified Miranda reading warnings are already done across the country in different places. So I counter that argument by saying that. I want to acknowledge that there was fiscal notes that were submitted, and it is impossible for the counties to have known what the real fiscal impact was because this amendment changes the original language. And so I want to be fair to the opposition who may say, look, we don't even know what the fiscal impact is at this point because this new language, and that is true. So please do not rely on those fiscal impacts. And I want to remind you that this is a policy committee. Should we move this policy out because we agree that we should ensure that our kids understand what rights they're waiving away, that I will then engage in that difficult money conversation in the money committee, but we discussed the policy here. And with that, Mr. Chairman and Madam Vice Chair and members of the committee, I apologize for the lengthy intro, but it was very important to lay the foundation so that we could have a meaningful dialogue. And with that, any questions for Dr. Olivares and myself, we're here for that. Thank you.
Thank you for your presentation, Assemblyman Flores and Dr. Olivares. I do have a couple of questions so far who I have on the list, and this is the order we'll go in. We'll start with Assemblywoman Kasama, then Assemblywoman Bilbray-Axelrod, followed by Assemblyman Wheeler. Assemblywoman Kasama, please go ahead.
Thank you, Chair, and thank you, Assemblyman Edgar Flores. Great presentation. I have two quick questions, if I indulge the Chair. One, Dr. Ana Olivares, if we could have a copy of her statement and presentation. I just thought it was very good, outlined a lot of good information. I don't see it's one of the exhibits here, so would certainly appreciate that because I thought you went through that very thoroughly and would be able to reference that and look at that. And then also under amendment number 1, where you have the change, except as otherwise provided in subsection 2, a peace officer or probation officer who takes a child, you crossed off under 15 years of age. Below in the green, you reference a youth of 17 years. Does the age need to be back in that section that you took out the 15 years? Because I see you crossed off the years, and for consistency, doesn't 17 need to be back up there? Thank you.
Through you, Chairman Yeager, to Assemblywoman Kasama, Assemblyman Edgar Flores, for the record. Assemblywoman, thank you for that question, and I appreciate that. I want to ensure that nobody by any means of the imagination thinks that LCB prepared this. They would have done a much better job than I. So the short answer is the way amendment number 2 reads, with the actual usage of 17 years of age or younger, will reflect and be and will mirror the proper usage of whatever phrasing LCB comes up with to ensure that it is someone age 17 and younger. In other words, section 1 will read, rather than saying child, will read a youth 17 years of age or younger. Or if the definition already in the NRS of child is 17 years of age or under, section 1 sub 3 will then be changed to reflect that. So there will be consistency and a mirror of the language in that sense.
Okay, so it will be adjusted. Thank you so much.
Thank you, Assemblywoman.
We'll go next to Assemblywoman Bilbray-Axelrod.
Thank you, Chair, and thank you, Assemblyman Flores, for bringing this bill. I have to be honest, it brings back a lot of memories from last session when I brought the marriage bill, and just, showing that children, their brains just aren't where we are as adults. So I have a question. I was looking at the letter in opposition from the sheriffs and chiefs, and I know that they're working off of the original bill based on the date. But the incident that they are speaking of hypothetically, a little boy steals, or they believe steals, a bike out of a garage, and the person sees them, going north, and so the police go after them, and they're basically making the statement that the officer can't question Johnny, is what they named the boy, because of this bill. Now, my understanding is that Miranda rights are read to once you're being arrested. So an officer could still have a conversation and surmise what the situation was. Is that correct, or is this bill somehow not allow an officer to do that?
Thank you, Assemblywoman, for that question. Through Chair Yeager to Assemblywoman Bilbriac, so right, Assemblyman Edgar Flores, for the record. The short answer is it happens every day. There are millions of YouTube videos, and I say that anecdotally and jokingly, where individuals are constantly engaged by law enforcement. Now, whether or not a child in that scenario would want to continue that conversation, or an adult and want to continue a conversation where they don't yet have the probable cause to make that arrest, is a different question. But in the course of an investigation, that always happens. Law enforcement does not somehow sit quietly on their hands and say, there's a course of an investigation, but I don't know how to establish probable cause yet to make that arrest. So what I'm going to do, or I can't articulate reasonable suspicion or whatever it may be. And again, I don't want to get too heavy into those standards. That's for a separate conversation. But law enforcement doesn't say, I'm not going to engage them. That never happens. They consistently engage individuals all of the time until they can get to a point either where they've heard something, they've seen something that they then want to pursue further, or whatever they have to do. They talk to other individuals, right? In no way does it impact the scope of the investigation that happens before you actually apprehend somebody, read them their Miranda rights, and want to engage in a custodial interrogation.
Thank you.
We'll go next to Assemblyman Wheeler.
Thank you, Mr. Chair. I appreciate it. And Assemblyman Flores, I'm sorry we couldn't get together last night because I did have a lot of questions on this bill, so I guess I'll give them to you now. But it's been a while. I think when I first joined Judiciary back in 2013, since I've read the actual Miranda versus Arizona decision, because I know one of the bills came up during that period on that. And I think you're correct that it actually says in there it must be knowingly and intelligently. At least that's the words that you just used. So I've seen cases over and over, and even with adults, where the judge goes in and throws out a convention even though they were properly Mirandized, because the defendant didn't know exactly what was being said, didn't know what his rights really were. He just waived them anyway. And Dr. Olivares, for instance, said that, the brain doesn't develop until mid-20s. I think that was what she said, but I'm pretty sure. So I can understand that. Now, doesn't the judge at this point have the right to say the confession was not proper, even though they were properly Mirandized, because this child did not knowingly and intelligently, in your words, Assemblyman, waive those rights? His parents should have been there, a lawyer should have been there, someone else should have been there. So by passing this bill, aren't we actually removing not just prosecutorial discretion, but judicial discretion in some cases? And if Dr. Olivares is right and the brain doesn't develop till mid-20s, why are we letting these people vote? That's just a sidebar. Thanks.
Thank you, Assemblyman, for that question. Chairman Yeager, through you to Assemblyman Wheeler, Assemblyman Edgar Flores, for the record, I very much appreciate that point. I'd like to first start off by saying how overly burdensome and expensive it is that we would have to allow for a kid to go through the process of a public defender, to show up to court, get attorneys involved, spend thousands of dollars, have an entire potential jury before we can correct the wrong of that member of law enforcement? If we want judicial efficiency, why not preemptively ensure that the minor understands what's happening on the front end, rather than having to go through this lengthy process, expensive process, burdensome process, very dramatic process for a child to get to where we could have fixed it in the front end? I'll say that first. Second, I absolutely agree with you. In fact, JDB, J as in Jason, D as in Delta, B as in Bravo versus North Carolina, a 2011 Supreme Court case, Justice Sotomayor in that very case said, "It is beyond dispute that children will often feel bound to submit to the police questioning when an adult in the same circumstances would feel free to leave, seeing no reason for police officers or courts to blind themselves to the common sense reality. We hold that a child's age properly informs the Miranda custody analysis." And I say that because you're hitting on a very important point, which is, how do you knowingly, intelligently waive away a right? And the Supreme Court has already discussed it in that very specific case, where they're saying we don't know and don't think that they do, or that they understand what they're knowingly and intelligently doing. So we have a Supreme Court case on point that 100% delineates and talks about exactly what you just said. We will in the future, I absolutely believe, be having conversations whether or not 18, a number that we selected years ago, or 21, is actually an age of adulthood, of understanding consequences. We will definitely and absolutely be engaged in that conversation. Now, I know you brought up why do folk the age of 18 can vote, and that's a conversation to be had in a different bill presentation, a different bill hearing. But the question that is on the table here is, should a minor be allowed to waive their rights when we are making the argument that they cannot do it knowingly and intelligently? Thank you, Assemblyman.
Okay, thank you. Just follow up, Mr. Chair, very fast.
Please go ahead.
Okay, thank you. You brought up the cost, and as I sit here and look at 12 fiscal notes, and some of them actually don't know the cost yet and said that in their fiscal notes, but others have. There's hundreds of thousands already. So what's the cost of doing it as well? So we got to look at both sides. And thank you. I appreciate you bringing this bill forward, Mr. Flores. I think it's interesting, and let's, go have a beer and discuss it.
Thank you again, Assemblyman Wheeler. I appreciate that. Through you, Mr. Chairman, to Assemblyman Wheeler, Assemblyman Edgar Flores, for the record, I will say, I do think that we have to look at all sides of cost, and there is a fiscal question here that you have to take into account. But I just want to follow up with, what is the cost to society that we have to correct something that could have been prevented? I genuinely believe that this could have been cheaper if we look at all those cases that have gone all the way to that level, that had to get all the way to that point of a judge intervening to correct the wrong that was done at the very beginning. I genuinely think that the cost to us would have been cheaper, but more importantly, as a society, the cost of protecting our kids is much more important than that fiscal impact.
Thank you. I ever get in trouble, you're going to be my lawyer, buddy.
Thank you, Assemblyman.
Okay, so we're going to take, what we're going to do is take a couple more questions, and then we're going to have to let Assemblyman Flores get over to Government Affairs, where he has a bill he's going to be chairing, a hearing he's going to be chairing at 9 o'clock. So I'm going to take 2 more questions before we move on from the presentation, and those 2 questions will be from Assemblyman Ohrenlicker and Assemblywoman Cohen. So please go ahead, Assemblyman Ohrenlicker.
Thank you, Mr. Chair, and thank you, Assemblyman Flores, for bringing this bill. It's a very important bill, and I'm glad to see that we're considering it. I have a question about your proposed Amendment 3. I think, as you say, it's very good to have revised Miranda warnings for minors. But if we put this in statute, I wonder if it makes it too hard to modify it over time as we learn more about best practices. So is there a way to maybe give the Nevada Supreme Court some kind of authority guided by neuroscience understanding to modify what we set out in statute?
Thank you for that question, Assemblyman. Through you, Chair Yeager, to Assemblyman Ornlicker, Assemblyman Edgar Flores, for the record. I very much appreciate that sentiment. In fact, if I can be honest to the committee, I've devoted an excessive amount of time and sleepless days for a few weeks here in trying to come up with an understanding of what the best approach on that modified Miranda language is, for the reasons you've stated, but more importantly, for the reasons that there's a whole host of other phrases that we could use. I vetted this through a lot of elementary school teachers who, by the way, I need to take this opportunity to say thank you to them, to all you that read this to your students and gave me feedback. I'm so incredibly grateful to you because you're part of the genesis of why this bill is happening. So thank you to all our teachers that came through. I am open to the idea, Mr. Ornlick. Excuse me, I think I accidentally muted myself. I am open to the idea of engaging in that conversation. I am not in any way making the argument that these are the only words we could use. In fact, reasonable humans can sit in a circle and maybe further delineate some of this or bring out more from it. So I am open to that, Assemblyman Ornlicker. If you have any other ideas, I am here for you.
Okay, before we go to our last question, a couple things I wanted to note for the record. Assemblywoman Krasner is with us. She has been with us for quite some time, so please mark her as present. And then Assemblyman Flores, I just wanted to make one correction to the record. I think you referenced the bill from 2019 and perhaps gave the wrong bill number, so it is Senate Bill 353. I think you said 535, so I think those were transposed. But if our committee secretary could just make that correction in Assemblyman Flores' testimony, so that way if folks want to go back and read that bill, they'll have a way to do that. So with that, we're going to go to Assemblywoman Cohen for our final question of Mr. Flores. Please go ahead.
Thank you, Sharon. Thank you both for the presentation. I have a question about false confessions because I looked up JDB and was reading some articles about it. And in the articles it discussed how juveniles make up a disproportionate number of those who falsely confess. And I think the number they said is that upwards of a third of, in some studies, they've shown that up to a third of false confessions were from juveniles. So my question for you, Assemblyman and Dr. Oliveras, is if you do have any comments about false confessions, because I think you kind of touched on it, but didn't actually go in depth in that. But more than that, what I'm looking for is a response. I'm not sure who's going to be in opposition, but if any of the law enforcement agencies are going to be in opposition, when you testify, I would ask that you let us know what your agency is doing to prevent false confessions in juveniles.
Thank you, Assemblywoman, through Chairman Yeager to Assemblywoman Cohen, Assemblyman Edgar Flores, for the record. There is a whole host of documentaries, most recently and notably the Central Park 5 that I believe a lot of us saw on PBS. But there is a whole host of documents online that you can do a quick Google research of, where it goes deep into false confessions. And for the sake of just clarity, this goes to the very heart of what we are talking about here, that there are kids who, because they hang out with older kids who are now over the age of 18, are told, look, just take the hit. You know, you can be part of the gang now, you can be part of the crew. You know, you're gonna show your colors, this and that. There are kids who sometimes will take the blame to protect their older siblings or parents or family members. There are kids who are put in a position, if you have an opportunity to just look at the Central Park 5, where you'll see that within the interrogation tactics that were used, they'll say, well, kid A is saying you did it. Now kid B's like, what? Kid A said I did that? Now kid B is in a responsive, emotional, reactive state, saying, well, kid A is the one that actually did it. And then they're doing that with kid C, kid D. There's all these different intimidation tactics and tactics that are used that often lead to this very exact issue that we're talking about, false confessions. And I'm just using that as an example because you can easily look that up and give yourself an opportunity to see some of that, watch the video, and just kind of walk you through that. But this is exactly at the heart of what we're getting at here. And I will say that in the Miranda v. Arizona case, if you read a lot of the opposition that was submitted against the Miranda rights, the very first thing that you heard from a lot of law enforcement agencies was, "You're tying our hands. You're no longer allowing us to do our job by doing this. You're changing the procedures we have in place." That's what you're going to hear again today. And I ask you to just keep in mind what is at stake, and it is the rights of a minor and ensuring that they know what they're waving away.
Thank you, Chair.
Thank you. So I realize there probably are additional questions, but due to time and due to Chair Flores having to get over to Government Affairs, we're not going to have time for additional questions for him this morning. However, as you all know, he's in this building and more than willing to talk about this bill. So if you do have additional questions, please follow up with him at another time. Chair Flores, I know you have to go over to Government Affairs, so I'll excuse you to do that now. If you are able to get back for concluding remarks, great. If not, we could either waive those or Dr. Olivares could perhaps make some concluding remarks on your behalf, but want to thank you for being here this morning and spending about an hour with us presenting Assembly Bill 132.
Chairman Yeager, Assemblyman Edgar Flores, for the record, if I may make a request, I know our vice chair and I really need to be at the other hearing, but if we could potentially allow for all the opposition to go first, and then what I could do is briefly close out my remarks at that point, and then afterwards you can go into the neutral and support if that would work. And Dr. Olivares will stay on the line to allow for any additional questions that are addressed to her. If that is the pleasure of the chair. Otherwise, Mr. Chairman, I can jump off now and I can ask Ms. Olivares to do the closing remarks. It is whatever you wish.
Thank you, Assemblyman Flores. I would like to stick in our traditional order, so I'll do support first, and then opposition and neutral. And if you're able to jump on, great. If not, we'll ask Dr. Olivares to take your place there in the concluding remarks.
Thank you, Mr. Chairman.
Thank you, Assemblyman. So at this time, I'm going to go to testimony in support of Assembly Bill 132. I don't believe we have anybody on the Zoom with us, but I'm sure we have some folks on the phone. Before we go to the phone line, I just want to let folks know who are wishing to testify in any particular position on this bill to please keep your remarks to 2 minutes. I will be timing. I want to give everyone a chance to speak. So if your remarks can be done in less than 2 minutes, that's great as well. We do have another bill on the agenda today as well as a floor session, so that's why we have to get through this bill in a timely fashion. So if you could do that for us, I think it'll help us move along smoothly, and it'll give everybody a chance who wants to testify the opportunity to do so. BPS, at this time, could we go to the phone lines to see if there's anybody there who'd like to testify in support?
Yes, good morning, Chair. To testify in support of Bill AB 132, press *9 now to take your place in the queue. Would the caller with the last 3 digits of 556 please slowly state and then spell your name for the record? You will have 2 minutes and may begin now.
Anne Marie Grant, ANNEMARIE GRANT. I'd like to thank Assemblyman Flores for bringing this bill forward. Studies of young people's understanding of legal processing and the consequences of various legal choices, such as forfeiting their right to remain silent or to have an attorney, show differences between those under 18, often misunderstand the concept of a right in general and of Miranda rights in particular. They perceive fewer alternative courses of action in legal proceedings and tend to concentrate on short-term rather than long-term consequences. For example, younger youth often misconstrue the right to remain silent, believing it means they should be quiet until they are told to talk, nor do they completely understand the right to have an attorney present without charge before they talk. These misunderstandings raise concerns about children's and young adolescents' competence to stand trial in adult court. The Sheriffs and Chiefs Association opposed the bill, and they cite the restrictive language of Section 1.3 would make it a burden to the juvenile and the parents. I propose it would be more of a burden to all for a youth to be dragged through the justice system. They see it as a burden in this day and age. I see it as protection for our most precious commodities, our youth. Please support this bill. Thank you.
Thank you for your testimony, Ms. Grant. BPS, let's take the next caller, please.
With the caller with the last three digits of 611, please slowly state and then spell your name for the record. You will have 2 minutes and we begin.
Good morning, Chairman Yeager and members of the Assembly Judiciary Committee. My name is John Piro, Johnpiro, and I'm testifying on behalf of the Clark County Public Defender's Office and Nevada Attorneys for Criminal Justice. We recognize imbalances of power between adults and children in all other aspects of the law, and it is time to officially recognize it here. I do not believe that the concerns of the Nevada Sheriffs and Chiefs are founded based on the one-off hypothetical presented. Children are more vulnerable, and cannot understand things the same way. We recently just stopped chaining up children in Nevada after a long fight. And as Frederick Douglass said, without struggle, there is no progress. This is a struggle worth having for much needed progress on protecting children when it comes to waiving their Miranda rights and giving them counsel in difficult situations. And we strongly urge the support of this committee of this bill. Thank you, and that concludes my testimony.
Thank you for your testimony, Mr. Piro. BPS, let's take the next caller, please.
If you have just joined the meeting, we are currently in testimony in support of Bill AB 132. Press star 9 now to take your place in the queue. With the caller with the last three digits of 037, that's 037, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Tanya Brown, TONJABROWN, advocates for the inmates and the innocent. We strongly support this bill. Now, there was some testimony given during the presentation, and I don't know if I missed it or it wasn't brought up. But most officers are truthful, but juveniles and even adults they believe that the officers are being truthful when they're talking to them, and it puts pressure on them, on the defendant. When an officer is allowed to get away with lying to that individual, you are more likely to get false confessions. So I kind of wanted to touch on that. I wanted to touch on the Miranda issue. Now, I don't know how many cases over the last several decades since Miranda was first established that were juveniles and were incarcerated and still are incarcerated in our Nevada prison system based on no Miranda given. Now, I'm just going to read just a small portion of an adult Nevada Supreme Court case in which it states, appellate contends that his interview constituted a custodial interrogation and that evidence derived from that interview should have been suppressed because he was not advised of his rights under Miranda versus Arizona. And then it goes on to state that the counsel was not ineffective for making a reasonable strategic choice. Basically, what the order is saying is that all evidence that was seized prior to trial during interrogations, and the individual was not given Miranda, if the attorney argued that it was a strategic decision not to suppress the evidence and take their chances at trial, and that's what they do, then it's not a violation of the Miranda rights. So I'm curious as to how many people would have been affected by no Miranda warning, even as a juvenile today, and will this move forward? Could it possibly be to include retroactive, to look at some of those cases in the past where Miranda was never given in cases, and yet the courts have upheld that Miranda wasn't necessary, even though the evidence obtained during the interrogation was without Miranda? Also,
Miss Brown, could you please wrap up your comments?
okay, I guess that's pretty much all. I am in support of this bill, and I think it is a long overdue bill. Thank you.
Thank you for your testimony, Ms. Brown. BPS, are there additional callers in support?
Yes, Chair, there are. With the caller with the last three digits of 018, please slowly state and spell your name for the record. You will have 2 minutes and we begin. Caller with the last three digits of 018. Press *6 to unmute yourself and you may begin your testimony. With a caller with the last three digits of 318, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary. This is Kendra Birchie, Kendra Bertschy, with the Washoe County Public Defender's Office. We want to thank Assemblyman Flores for bringing this crucial bill to ensure that the constitutional rights of our children are protected. States across our nation are looking into ways to protect our vulnerable youth by taking steps to reduce coerced and wrongful confessions. The Juvenile Law Center reports that there is unfortunately a disproportionate of individuals who are arrested and interrogated. And those individuals are particular high risk of facing interrogations and coercion. They also found that adolescents waive their Miranda right at an astounding rate of 90% and also make false confessions at exponentially higher rates than adults. The Innocence Project has found in studies that 25% of wrongful convictions were overturned through DNA testing involving false confessions. We appreciate the attempts in order to ensure that children understand the Miranda rights, something that my adult clients don't always understand when making potentially life-altering decisions with someone who's on their side. The requirement of recording is crucial because not all officers or probation officers wear body cameras. If this bill were passed, my office would create an on-duty system where we would have one phone number for police agencies to call during off hours in order to ensure that we have an attorney timely present, either by phone, video conference, or in person. The Department of Indigent Defense Services, which was established by this legislative body through AB 81, is also required to provide this oversight and identify ways in order to ensure best practices for delivering the most effective indigent services, including ensuring access to attorneys. Thank you so much for bringing forward this bill, Assemblyman Flores, and please pass AB 132 to ensure that we protect our children. This can be done in Nevada and should be done.
Thank you for your testimony, Ms. Birchie. BPS, let's take the next caller in support, please.
With the caller with the last three digits of 130, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good morning, Chair and members of the committee. For the record, my name is Christine Saunders. That's Christine Saunders, and I'm a policy director at the Progressive Leadership Alliance in Nevada, here in support of AB 132. We believe that all youth should have access to the resources they need to navigate the criminal justice system, regardless of the severity of the charges. Provisions in AB 132 are connected to the foundational principles for human rights of children and will help increase fairness and better ensure justice for youth in Nevada. We urge your support. Thank you.
Thank you for your testimony, Ms. Saunders. BPS, let's take the next caller in support, please.
With the caller with the last three digits of 080, please slowly state and spell your name for the record. You will have 2 minutes and may begin. Caller with the last three digits of 080, press *6 now to unmute yourself and begin your testimony.
Thank you, Mr. Chair, members of the committee. Brad Keating for the record, B-R-A-D, Keating, K-E-A-T-I-N-G, representing the Clark County School District. We appreciate you all hearing this bill today. AB 132 is an important bill for the Clark County School District, and we appreciate Assemblyman Flores working so closely with us on this bill. His work on making sure the bill works for the Clark County School District's police services and making sure that this hotline is created so that we could reach out and make sure that students do understand their rights. We already provide the Miranda Plus, but we think the hotline is an incredibly effective way to make sure students are engaged and understand what is happening as we begin a process of working with those students. So we thank Assemblyman Flores for bringing this forward and urge the committee's passage. Thank you.
Thank you for your testimony, Mr. Keating. BPS, let's take the next caller, please.
If you've recently joined the meeting and you would like to testify in support of Bill AB 132, press star 9 now to take your place in the queue. Would the caller with the last 3 digits of 031 please slowly state and then spell your name for the record? You will have 2 minutes and may begin. Caller with the last 3 digits of 031. Press star 6 to unmute yourself and begin your testimony.
For the record, my name is Jocelyn Cuevas, Joseline, Cuevas, Cuevas. Chair Yeager and committee members, I am an organizer with Mi Familia Vota and a member of the Nevada Immigration Coalition. We are here in support of AB 132, with the added amendment to include children of all ages. Minors cannot do many things without parental or guardian consent. First and foremost, we want to thank Assembly Flores and the presenters for presenting AB 132. It is important to understand that children who are being interrogated are protected, as well as the entire juvenile justice system. This bill will give us much needed transparency we have been asking for. After being taken into interrogation, immigrant children can be put into high risk for deportation than they were in the first place, especially without transparency. In a situation of fear, children are incapable of making their own decisions or giving their own consent. Once an immigrant minor has been placed in police custody, there would be a record of them. Being in a state of fear would not allow them to make the correct decisions and potentially admit them to things that they did not do without a lawyer present. We need to ensure we are protecting our immigrant children and we are not putting them in high risk for deportation. We can do this by supporting AB 132 and asking if this bill could be extended to any circumstances where a child could face criminal charges, including a misdemeanor. This bill will protect our immigrant communities from falling into the criminal justice system. We ask the committee to support AB 132. Thank you for your time.
Thank you for your testimony, Ms. Cuevas. BPS, are there other callers in support?
Yes, Chair. Would the caller with the last 3 digits of 018 please slowly state and spell your name for the record? You will have 2 minutes and may begin.
Good morning. My name is Jim Sullivan, JIMSULLIVAM, and I represent the Culinary Workers Union Local 226. The Culinary Union supports Assembly Bill 132 because it ensures the fulfillment of the constitutionally protected right to legal counsel for all children in Nevada, regardless of background, and ensures that minors' legal rights are protected throughout the judicial process. The Culinary Union represents 60,000 working families in Nevada. The majority of members are people of color and tens of thousands are parents. We know that there are significant racial disparities in the outcome of our legal system, and that's why we must standardize and streamline the juvenile judicial process, which will result in more just legal outcomes. A presumption of child indigency will ensure a speedy legal process and avoid a number of complicating factors stemming from a family's lack of ability to pay for an attorney and the burdensome requirement that they prove that lack of ability. In addition, ensuring recordings of juvenile interrogations are mandatory will protect all parties by encouraging legal and ethical behavior and creating a clear record of facts. While we would like to see this bill apply to any circumstance where a child could face criminal charges, this is a great first step. AB 132 is a common sense fix that will aid in the fulfillment of children's constitutional rights. As the largest organization of parents in Nevada, the Culinary Union strongly supports AB 132, and we encourage you to do so as well. Thank you for your time.
Thank you for your testimony, Mr. Sullivan. BPS, let's take the next caller, please.
Chair, there are no more callers in support of AB 132 at this time.
Thank you, BPS. I will note for the record that uploaded on Nellis, give my computer a second to find it here. There is a letter in support from the Nevada Attorneys for Criminal Justice. I think Mr. Pirro testified on their behalf as well. And there also is another letter in support from an individual, Zachary Kenny. So I wanted to flag those for the committee, that there are a couple other supportive letters as exhibits. With supportive testimony behind us, I'll now close the phone lines to support. BPS, I don't think we have anybody on the Zoom with us in opposition, but let's go to the phone line. I think we have a number of folks there who'd like to provide testimony in opposition.
Thank you, Chair. To testify in opposition of Bill AB 132, press *9 now to take your place in the queue. With the caller with the last three digits of 229, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair and Committee. This is Jamie Rodriguez. That's JamieRodriguez. I'm the Government Affairs Manager for Washoe County. I want to start by thanking the bill sponsor, Assemblyman Flores, for meeting with us regarding the proposed bill, the amendment, and some of our concerns. I know that my juvenile justice folks will be testifying, so I'm going to let them get into the concerns regarding the policy impacts for that department. But I did want to speak to, as the Assemblyman stated, that our fiscal note in the system is not correct. And we are still working to really understand what the fiscal impact to the county would be based on kind of what that final bill language looks like. But for starters, I want to highlight that just talking about, an on-call public defender to be available for all juveniles, that's starting at about $80,000 based on some comparisons we were able to do with our district attorney's office. And that's kind of just the start of it in terms of fiscal impacts. And while I know that this is the policy committee, I want to highlight that local government fiscal impacts do not default to the money committees unless there's an appropriation or a state impact. And based on my interpretation of the bill, I don't believe that this is something that would likely go to one of the money committees. So we look forward to continuing to work with the sponsor regarding some of our other concerns, but really just wanted to highlight that fiscal concern from the county and apologize that while the amendment would have changed the fiscal impact anyways, that fiscal note in the system is not correct. So thank you very much for your time.
Thank you for your testimony, Ms. Rodriguez. BPS, let's take the next caller, please.
With the caller with the last three digits of 210, please slowly state and spell your name for the record. You will have 2 minutes and may begin now. Caller with the last three digits of 210, press *6 now to unmute yourself and begin your testimony.
I would like to thank the Assemblyman Flores and the committee for hearing us today. My name's Michael Wheelahan, Michael Whelihan. We met with Assemblyman Flores yesterday. We opposed the bill because we feel there's some unintended consequences that will occur. We're not opposed to Miranda right changes. We just want to make sure that there's no unintended consequences. We just got the bill late last night. We're not in support of taking the parental rights away. Best practice in juvenile justice is to allow family engagement. So as a parent, I don't think that's appropriate. As far as the department goes, there's a concern that the bill in Amendment 1 talks about custody, and the intent of the bill is unclear because custody for a peace officer or law enforcement officer is once you put a youth in handcuffs, it would be considered custody. So we need to understand what the impact or what the intent of that piece of the language is. We're also concerned that on any given weekend we can have 20 to 30 youth detained in Clark County. If the attorney doesn't answer the phone or if there's a backlog of calls waiting, kids are going to get detained. And there's a huge fiscal cost, especially with Clark County when it comes to that. And we have concerns about conflicts between attorneys. If you've got people staffing the phone and they have similar youth or adults that they're working on the same case. So there could be conflicts with attorneys. And the staffing of the 24 7-hour call is going to be very important to keep kids out of our institution. Over the last 4 years, DJGS has diverted 14,000 youth out of the criminal justice system to our county harbors, and in 2019, DJGS had 11,700 referrals, which 5,700 were diverted out of the system. So we have some concerns with that. And then Amendment 2 is kind of unclear because Assemblyman Flores talked about they will not be able to waive their rights, but when you read the Miranda warning, it says if you do not want to talk to me, if you do want to talk to me, I can tell the judge. And then later in the Miranda warning, it says that they can't. So I think there's some inconsistencies in the language, and the fiscal impact is going to be huge. And for an example, if a kid has a gun or they're in a car and 5 or 6 people are in the car and there's a gun found in it, at that point, the law enforcement agency would probably place everyone in handcuffs. So what would be the unintended consequences that all 6 would be arrested? And then if someone doesn't answer the phone, how long do the police, law enforcement agencies have to wait before they detain the kids? And then you're going to have some scheduling issues once a kid is detained in our juvenile detention center. Law enforcement could have days off. The attorney could have days off. So the kid's going to be sitting there in detention. DJGS has tried to lower our detainment over the last years. We want to keep kids out of detention. We want to make that clear that is our goal, is to keep the kids out that shouldn't be there.
Mr. Wheelahan, could you please wrap up your comments, please?
Yeah, so we have limited bed space, and this bill could impact and cause overcrowding in our institutions. Thank you for your time.
Thank you for your testimony, Mr. Wheelahan. BPS, let's go to the next caller, please.
Call-in user number 1. Please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary Committee. My name is Alex Ortiz, representing Clark County, ALEX-ORTIZ. Even though this is a policy committee, it is our only opportunity to express our concerns about the fiscal impact of Clark County. Because Clark County opposes Assembly Bill 132 as written and amended due to the fiscal impact on Clark County as a whole. I want to thank the sponsor, Assemblyman Flores, for taking time to discuss our concerns with him. Clark County's opposition is based on the fiscal impact of the county and not the policy issues being discussed today. Some of those policy issues were mentioned by our Assistant Director of Juvenile Justice Services prior to me. We did submit a fiscal note a while back based on the original bill, which is on Nellis. However, that fiscal note is no longer accurate based on the conceptual amendments proposed today by the sponsor. I want to thank Assemblyman Flores for also making this clear on the record. We will review the conceptual amendments in more detail and communicate our concerns with the sponsor. Once again, I want to thank Assemblyman Flores for meeting with us and look forward to working with him on this bill. Thank you for your time today.
Thank you for your testimony, Mr. Ortiz. BPS, let's take the next caller, please.
With the caller with the last 3 digits of 705, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good morning, Chair Yeager and members of the Assembly. My name is Elizabeth Flores, E-L-I-Z-A-B-E-T-H, Flores, F-L-O-R-E-Z, and I am the Interim Director of the Washoe County Department of Juvenile Services. In juvenile services in Washoe County, we recognize the critical importance of due process rights of any person, including our youth. We also recognize that the adolescent brain is distinct from adults. The previous presenters provided valuable information about both adolescent development and instances of bad custodial interrogations. As a probation department who continues to embrace juvenile justice reform, who continue to divert the vast majority of referred youth away from formal court proceedings, and who pride ourselves in developing positive relationships with them, we fear this legislation will result in extended detention time for our youth. Our mission is to serve both youth as well as our community, who we have sworn to protect. To Assemblyperson Cohen's previous question through Chair Yeager, both law enforcement training as well as adolescent-specific training inform our practices around proper custodial interrogations. As I listen to testimony, I'm curious to know the prevalence of improper interrogations in the juvenile justice arena. With that, I will conclude my statement and thank you.
Thank you for your testimony, Ms. Flores. BPS, let's take the next caller, please.
With the caller with the last three digits of 896, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good morning. This is Jolie Wicks. First name J-O, capital L-E-E. Last name is W-I-C-K-E-S. I am the Chief Deputy District Attorney for Washoe County Juvenile Division, and I am speaking on behalf of the Nevada District Attorneys Association. We are here in opposition to Sections 1 and 2 of the bill before us this morning, but we believe that there are some merits to the language proposed by Assemblyman Flores in Section 3 and believe that we should engage in some further discussions. One of the concerns I have about the specific language is that it appears to me to be at odds with the Nevada Supreme Court case law requiring that the youth be told that they have the right to have a parent present. It is in large part somewhat compatible with the training that my office provides whenever possible to post-training and new officers about explaining Miranda and answering questions and providing information to youth in a youth-friendly manner. With regard to Sections 1 and 2, I don't believe that it's a bright-line rule regarding custodial interrogations. Custodial interrogations is fact-specific and often litigated. We are also concerned about conflicts of interest if there is an attorney available to field phone calls. How many attorneys would be available, and would there be conflicts of interest? In the 2019 session, there were discussions about waivers of conflict of interest that requires that the youth on both sides of the possible conflict be advised and both agree to the waiver of the conflict. We believe that this will have a huge impact on juvenile justice in the state of Nevada, including law enforcement's ability to conduct in the field investigation due to the fact that custody, is a little bit more complicated than putting the handcuffs on and putting you in the car. So we thank Assemblyman Flores for bringing this bill. We just think it's an important discussion, and we look forward to future discussion.
Thank you for your testimony, Ms. Wicks. BPS, let's take the next caller, please.
Chair, there are no more callers in opposition of Bill AB 132 at this time.
Thank you, BPS. Could we just have one more call for opposition? I had some other folks signed in, and they may not be on the phone line, but just want to make sure that they had a chance to participate if they're still out there.
Yes, Chair. If you'd like to testify in opposition of Bill 132, press star 9 now to take your place in the queue. With the caller with the last three digits of 456, please slowly state and spell your name for the record. You will have 2 minutes and may begin. Caller with the last three digits of 456, press star 6 now to unmute yourself and begin your testimony.
Good afternoon, Chairman Yeager, members of the committee. My name is A.J. Delap of the Las Vegas Metropolitan Police Department. Phonetically spelled, my last name is David Easy Lincoln Adam Paul. And thanks for that. I was a little slow on my keypad to get brought into the opposition, so I appreciate that, Chairman Yeager. Unfortunately, Las Vegas Metropolitan Police Department is opposed to AB 132 with the Conceptual Amendment presented by the bill's sponsor. The Las Vegas Metropolitan Police Department supports electronic recording of interrogations found in Section 1 of the amended bill. We also support notifying parents or guardians of juveniles who may be interrogated related to gross misdemeanor and felony crime investigations which they may be accused of. However, the Las Vegas Metropolitan Police Department does not support the requirement found in Section 1, subsection 3 of the amendment that requires the juvenile to consult with counsel prior to waiving the Miranda warning. This subverts the authority of the juvenile's parents or guardians to choose whether or not to consult counsel. Current Miranda warnings read to juvenile suspects end with a statement that allows the juvenile to speak to parents or guardians and for those parents or guardians to be present when interviewed. It is very likely with this amended language that the mandate to require counsel to be consulted prior to questioning will result in juveniles being simply arrested once probable cause is established without interviewing the juvenile at all. This will inhibit the ability for the other side of the story to be heard. There are many circumstances whereby interviewing the suspect, a more clear understanding of what events occurred can be established and that no arrest will be made. Thus, the traumatic event of being arrested can be avoided. I'd like to take a second, if I can, just to give a practical application of how Miranda works in the field, which was referenced to by the prior opposition testimony. I think it was Jolie Wicks. And she alluded to practical application in the field. The way that Miranda works is it's based on custody of the person. It doesn't necessarily have to do with a person being placed in handcuffs and loaded up in the back of a police vehicle. It has to do on whether or not that person is free to leave, and if the questioning being conducted by the law enforcement officer is going to potentially incriminate the juvenile or the adult. So that if you were to stop an individual who matched the description of a person who had committed a theft, a burglary, or other crime of gross misdemeanor or felony nature, you used your lights, your sirens, you gave them commands, your authority of being a police officer in uniform. The feeling of them not being able to leave is going to be key to that. And then if you continue on with questioning regarding a criminal act, which you have reasonable suspicion to believe they committed, you are now violating their Miranda. And at that time, Miranda would need to be given to them because they have no feeling of whether or not they can leave. So in a practical application of that, as it goes back to Director Spratley's scenario, if you have probable cause to make an arrest, then there is no requirement to interview the person that you have probable cause against. You can simply arrest them, unfortunately, without them being able to provide their story. So by giving them the Miranda, letting them know what their rights are, then they can choose whether or not they want to tell their story. And there may be information that they can provide which will, in essence, clear them of what they're suspected of doing. And that may prevent them from being arrested. So I'm certainly not a legal professor or an educator per se, but that's a quick reference to how Miranda works in the field. Excuse me. As far as Assemblywoman Cohen's question regarding measures we've taken to address false confessions, Assemblywoman Cohen, I will follow up with you in the committee. I don't feel comfortable addressing that because I'm not positive what we have as policy. But I will certainly look into that and get you that information as quickly as I can. And with that, I would like to conclude my testimony on AB 132, and thank you, Chairman Yeager, and members of the committee. Thank you.
Thank you for your testimony, Mr. Delap. BPS, could we check one more time to see if there's anybody in opposition?
To testify in opposition of Bill AB 132, press star 9 now to get your place in the queue. Chair, there are no more callers in opposition of the bill at this time.
Thank you, BPS. I will close opposition testimony. I'm now going to open neutral testimony. We don't have anyone on the Zoom in neutral. BPS, could we check the phone line to see if there's somebody there who'd like to offer neutral testimony?
To testify in the neutral position on Bill AB 132, press star 9 now to take your place in the queue. Chair, there are no callers in the neutral position. Oh, stand by. We've got a latecomer. Would the caller with the last 3 digits of 956 please slowly state and spell your name for the record? You'll have 2 minutes and may begin now. Caller with the last 3 digits of 956, I can see that you're unmuted. Can you begin your testimony now?
I'm sorry about that. Good morning and thank you, Chair. For the record, this is Liz Davenport, Lizdavenport, the legislative extern with the ACLU of Nevada. We appreciate Assemblyman Flores for bringing this bill, and at this time, our position is neutral. It is our position that this bill should extend to any circumstances where a child could face criminal charges, including on a misdemeanor. We understand the challenges faced in creating this bill and would appreciate engaging in conversations about how different interactions can create a criminal record and the impacts that causes. We do support efforts to protect children, especially at such an important and vulnerable moment in children's lives. Given the current climate, we believe it is important to move this bill forward. And for the reasons discussed above, the changes in this bill are enough to move us to a neutral position. We look forward to hopefully engaging in future discussions. Thank you very much for your time.
Thank you for your testimony, Ms. Davenport. BPS, could we check to see if there's anyone else in neutral?
To testify in the neutral position on Bill AB 132, press star 9 now to take your place in the queue. Chair, at this time, there are no more callers in the neutral position on the bill.
Thank you, BPS. Appreciate your hard work in getting all those callers connected and having them provide their testimony. I'm going to close neutral testimony, and right on cue, I see we have Assemblyman Flores back with us. Assemblyman, please go ahead and make any concluding remarks that you might have on Assembly Bill 132.
Mr. Chairman and Madam Vice Chair, Assemblyman Edgar Flores for the record. I wanted to just first again thank all of you for engaging in this meaningful dialogue, and I wanted to thank the opposition for reaching out and expressing their concerns. I am 100% convinced that they are not coming from a we don't want to help youth perspective. I genuinely believe that they are concerned about what this could mean procedurally and how it could impact their day-to-day investigations. But I would like to reiterate a few points. Number one, when Miranda v. Arizona occurred, that was the number one concern raised by law enforcement, how this would impact the investigative process. And today we cannot imagine a time where Miranda right is not read prior to a custodial interrogation, number one. Number two, we're talking and narrowly focusing on custodial interrogations, make it abundantly clear that the leeway and the tremendous amount of flexibility that we have prior to a custodial interrogation occurring, that investigative process is not being interrupted. I did hear, or better said, I didn't have an opportunity to hear all the opposition, and that was not purposeful. I have another meeting that I'm conducting, but I had an opportunity to just very briefly get some brief synopsis of some of the opposition. I heard that there was a concern about the amendment number 3, the modified Miranda, potentially being at odds with the Nevada Supreme Court, where there is a precedent that a parent can be present. I would ask, well, if that's the case, then does that mean that every single child interrogation that's happening right now, are we always ensuring that the parent is available? Is that the current rule and customary approach? Every single time law enforcement reads a Miranda rights to a minor, are they doing that now? But I just wanted to see if that's the case. I also saw that they're concerned that that there was an issue raised about not interviewing and arresting a minor can be more traumatic than interviewing and arresting a minor. I don't necessarily see the connection there, the nexus as to that. Arresting a minor will always be a traumatic experience for that child, and that's the whole point. If it's going to occur, because again, they've already gone through the Miranda ratings, they're already going to take that child into custody. If that's the case, then why not ensure that they first have an opportunity to speak to counsel? And then lastly, I'll just make the point that even if we said and modified that Miranda reading to say they have an opportunity to speak to a child, it doesn't negate the importance of saying you first will consult with an attorney prior to speaking to the member of law enforcement. I look forward to continuing this dialogue. Thank you to all of you for engaging in this conversation, and hopefully we can come up with something good during this legislative session. With that, I'll go ahead and close out my presentation. Thank you, Chairman and Vice Chairman and Vice Chair.
Thank you so much, Assemblyman Flores. Appreciate you being here and presenting the bill, especially trying to juggle your other duties over in government affairs. So again, we appreciate it, and thank you for being willing to work with all those who are interested in this bill.
Thank you.
With that behind us, I'm going to close the hearing on Assembly Bill 132. I'm going to ask all of the committee members to take a deep breath as we get ready for our next bill, which I don't think is going to take quite as long, but we shall see. And at this time, I will open up the hearing on Assembly Bill 32. Assembly Bill 32 revises provisions relating to the filing of a certain civil action regarding a motor vehicle. And I think the good news, committee, is I don't believe we have any amendments to the bill. At least I don't see any online. And I want to welcome to the committee Judge Melissa Saragosa, who also over the years has been a frequent participant in the Assembly Judiciary Committee. And she is here today to present Assembly Bill 32 to us and to answer our questions. So we'll give you a chance, Judge, to make your presentation, and then I'm sure we'll have some questions. And just before you get started, I want to thank you for your patience as we got through that first bill that we had to get through this morning. I know you've been waiting patiently, so thank you so much, and the floor is yours.
Thank you, Chair Yeager and committee. It's nice to have this virtual format where I can just sit and work at my desk and get things done while listening to a very interesting bill that preceded this one. Nonetheless, I know you all have had a long morning, so I'm going to get right into it. What I'd like to do to start on this bill is just to give you a glimpse of kind of what currently happens in court when these kinds of cases come before us. These are cases where a vehicle owner files a complaint for expedited relief, so emergency situations, for either what they believe is an illegal tow or an illegal immobilization of their vehicle, kind of putting the boot on the vehicle, so to speak. My intent is just kind of show you where we incur or encounter some problems in processing these cases. And then I'll go through the bill to show how the amendments, although it appears like there's a lot of blue on the bill, it's not really that much. It's kind of rewording and kind of just reworking a lot of what's already in existence. Currently on these cases, a vehicle owner will file this complaint for expedited relief. And in most cases, and I'm talking like 90% of the cases, they name the tow company as the defendant, yet the tow company is generally just taking their direction from the property owner. While the tow company is very knowledgeable, they're the most knowledgeable generally about the circumstances regarding the tow, they are not the person who directs the tow, and they're not the person identified in NRS 487-037 and 038 preceding this statute, who's authorized to order the tow of a vehicle. They're just an agent of the property owner. So the proper defendant is the property owner from which the vehicle is immobilized or towed. What happens when we get those cases now is the language of the current statute requires the court to set this emergency hearing. The idea is get to the court as quickly as possible. limit the, the storage costs that are, being added every single day, get to the court quickly, have the court make a determination as to whether the tow or immobilization, and I'm just going to use tow, but I mean immobilization on every time, whether or not that was lawful or unlawful, and make a determination as to what circumstances will the vehicle owner be able to get their vehicle back in a expeditious manner. But when we get these, we've got to set them for a 4 judicial day hearing, which is very fast. Oftentimes is not enough time to even get the property owner or the tow company or anybody served with notice of the hearing. 4 judicial days is tough. I'm going to be honest. It's hard. We end up continuing a lot of cases just to be served again, which makes it 8 days instead of what might be 5 judicial days. I didn't change that. That's not really my issue, but I throw that out there for your consideration. We do have to continue those cases a lot. And when we do, if you think about it, if we added 1 more day on instead of the 4 judicial days to give time for the constable to serve, they do it on an expedited basis, but we'd save 4 days worth of storage costs or 3 additional days of storage costs. Nonetheless, what happens is we set it for hearing, we get to the hearing, and now we have at the hearing, everybody's come down to the courthouse and we tell the plaintiff, the vehicle owner, I'm sorry, but you filed it against the tow company and that's the wrong person. We don't even have the right defendant here to even adjudicate your case. So in that situation, generally we allow them to amend if they know the property owner at that time, or we give them time to figure out who the property owner is, name the right person, and then we continue it and start all over again, which just ends up being, like I said, a waste of a hearing and a waste of everybody's time coming to the courthouse. We don't want people to come down when they can't realistically get their matter resolved. It's also common for the vehicle owner to delay in bringing this type of complaint for expedited relief. The nature of it, expedited relief, is intended to give people a rapid method of getting their vehicle back and getting that determination. But for some reason, and maybe it's just they're not knowledgeable in the process, they don't look into it, but we get these kind of complaints that are months after the tow. And it's not just infrequent, it's fairly regularly that we will get a complaint that's months after the vehicle was towed. And in this situation, the problem is the storage company, which generally is the tow company on their storage lot, has already gone through a whole separate other legal process to dispose of the vehicle through other legal means. Sometimes that's an auction of the vehicle. It's a collateral process that's not addressed by this bill. But realistically, that's what happens. So now the court is rushing to set a 4 judicial day hearing, bringing the people in, and yet we're left without any realistic remedy. The vehicle's already gone. It's already disposed of. I can't now order the tow company to return the vehicle to the property or the vehicle owner because it's already been disposed of through other lawful means. So the relief that they're seeking is no longer available. Instead, they're authorized, money damages through a full civil action. That's not an issue, or small claims or otherwise, but they wouldn't be authorized the expedited relief they're seeking. We also see this process frequently being utilized by individuals who've had their vehicles impounded or towed by a law enforcement agency. That is specifically not authorized in the statute. It says the jurisdictional, trigger for this kind of expedited relief is a tow pursuant to NRS 487-037 or 038. Neither of those covers a tow by law enforcement. So again, we set it for hearing. We bring everybody down only to tell them, I'm sorry, you've named the wrong person, and dismiss the case. Finally, we see vehicle owners file this type of complaint for expedited relief when they've already recovered their vehicle. They already have their vehicle back. So the expedited relief that they're seeking, again, is moot. They've already recovered their vehicle. Now, that's not to say that they may not have suffered the cost of storing and towing the vehicle, and they paid that to get their vehicle back. And maybe they're looking to recover that cost, but that's not what this statute is designed for. It's never been designed for that. That's not one of the remedies the court is authorized to give in this kind of a case. And it's also not the type of case that we would rush to set in those 4 judicial days. So with that kind of background of some of the issues that we see, my goal in bringing this bill forward was to really provide more guidance, more clarity, and allow the court to dismiss those cases on the front end before wasting people's time coming down to court and rushing for these hearings. So I'll start with, really it's all just one section because it's one statute, but I'll start with paragraph 1. What this does is clarifies that the expedited relief process in this statute is in addition to any other complaint they may file for money damages, any other civil action, whether that be small claims or civil or otherwise, that they still have that option. So it just distinguishes that. It allows the expedited relief to make that quick determination under what circumstances the vehicle owner may recover possession of the vehicle, depending upon whether the court finds it lawfully or unlawfully towed or immobilized. And it outlines 4 jurisdictional prerequisites, 3 of which are already in existing law. And then those are that it was towed pursuant to one of the statutes, that the owner believes that it was unlawfully towed, that the cost of towing and storing does not exceed the limited jurisdiction's $15,000 limit. And then the 4th is one that I have added and amended, and that is that the vehicle is being stored or is currently being immobilized as a result of the towing or immobilization, so that quick remedy that they're seeking is part of it's not moot, in other words. Paragraph 2 sets the deadline at 21 days. This 21 days, which is intended to be calendar days, is set because it offers the vehicle owner, one, that quick remedy that they're seeking, that quick determination, but it allows for us to have a hearing on the issue before the dates for which the storage company or immobilizing company or tow company, whoever's storing the vehicle, can exercise their right to dispose of the vehicle through other lawful means. So we want to make this a relevant hearing that we can give an actual remedy to. If they wait too long, then their remedy is lost. So the 21 days was kind of identified as a point where we could have that hearing before those other methods of disposition come into play. We outline in this section as well, part B, who the proper defendant is. And that comes from language that is taken from 487.037 and 038 as who's the person directing the tow. So it clarifies who they should be filing this complaint against rather than the tow company, who is just the agent and the person doing the bidding of the property owner who orders the car to be removed or immobilized. Paragraph 3 allows the court to dismiss those cases that are on the face of the complaint are not properly brought, so that the person can make those corrective measures, amend or refile in the proper name without the need to come to court and have that rush for the 4-day hearing. This will save us a lot of time and not having needless hearings that just need to end up dismissing a case. And section or paragraph 4, provides a couple minor changes. One is it converts the 4 working days to 7 calendar days. Again, if you wanted to give an 8th day or a 9th day, we want to make it as short as possible, but as reasonable as possible to get people time to come to get notified to come to court. I changed it to calendar days because that's the move that all of our civil procedural rules are changing to. The Nevada rules of civil procedure have done away completely with a judicial day count. It added a lot of confusion for a lot of courts because it was judicial days if it's less than 10 and calendar days if it's 11 or more. They scrapped that and completely moved to all calendar days. So my attempt was just to keep it consistent with what was already there for working days by 7 calendar days. It also maintains some consistency throughout the state because we all have different judicial days. In fact, with COVID this year, while the Las Vegas Justice Court had 5 judicial working days in a week, we converted to the 4, and we may be moving back to 5. That remains to be seen. But that was a cost-saving measure. So we want to keep it consistent regardless of what happens with judicial days. Also, it makes it easier for our case management systems to auto-calculate those days and avoid any human error in those calculations. Moving on to paragraph 5, this paragraph makes really what are minor amendments to the existing statute to bring it in line with the nature of this type of case. In reality, it's what we would call a declaratory relief. It's asking the court to make a declaration as to whether or not the vehicle was lawfully or unlawfully towed or immobilized. And then it gives, in reality, what happens when that, based upon the court's determination. So one of the things that I noticed in the bill that was really, in the original statute, it reads currently that if the court finds the vehicle was lawfully towed, then the court shall order the vehicle owner to pay the cost of towing and storage. Well, that's a little misleading because we don't really order the vehicle owner to pay that money. It's not a money judgment where we're giving the tow company a judgment. The tow company, one, is not even a party to this case. So we can't issue a judgment in favor of a non-party. But two, it really is not an order for the vehicle owner to pay. It's a determination that in order for the tow company to release the vehicle, they have to be paid first. But the vehicle owner gets that choice. They don't have to pay. They might determine on their own, forgo that payment and allow the storage company to recover their costs through other lawful means. They may decide the vehicle's value is not as much as the storage and towing costs. So they have to make a determination on their own. So I've kind of changed the language to bring it in line with that declaratory relief. And now it simply would state that the court would enter an order declaring the owner liable for those costs, but not necessarily a money judgment or an order to pay. Finally, paragraph 6, it is, excuse me, one area that's been commonly reported to me, and this is from the tow companies that regularly appear before me, is that if they're not in court and they don't know what happens in the courtroom and the vehicle owner just comes to them with an order, they don't know, they don't have any way of really looking at our docket to see whether it's a valid order, a real order or not. They had expressed to me through our conversations in discussing this bill that they would request that the court provide a certified copy to the vehicle owner. And that way the vehicle owner brings a certified copy to the tow company. So the tow company has some assurance that they're following the court's directive and that it is a valid court order. With that, I'm happy to answer any questions.
Thank you for the presentation, Judge Zaragoza. Appreciate that. We'll have some questions from members, I'm sure. I just wanted to ask a few that I think will be easy questions, but just kind of lay the groundwork a little bit for the issue we're dealing with. So as you indicated, there are a number of different actions, one might be able to bring to recover money damages for an unlawful towing, but this is an expedited action, an action for expedited relief. I just wondered if you could give us, obviously you're speaking for primarily Las Vegas Justice Court, but do you see a lot of these expedited cases being filed down in Las Vegas Justice Court? And if you're able to give any kind of sense of maybe what sort of numbers we're looking at on, I know probably it's different because of COVID, but in normal years, if you have any sense of what kind of numbers we're looking at on an annual basis, I think that would be helpful.
I can give you some anecdotal information or my observations, no hard numbers, because this particular type of case is not one that I'm not sure whether we code it differently. I may be speaking out of turn. If I can provide you an actual number, I will. I'll ask my staff to see if they can extract that data from our case management system. But I can tell you they're fairly regular. I mean, they're not the bulk of our caseload for sure. I would see when I had an all civil caseload, and we have 2 judges hearing all of our civil cases in Las Vegas Justice Court. When I held that calendar, I would say I would see on average, maybe 1 a week. So 2 a week with the other department, if that holds true, you're talking maybe 100-ish a year.
Thank you. That's helpful. And then in your experience handling these kind of cases, are the plaintiffs typically represented by counsel, or are these things that they tend to file on their own?
Always on their own. I don't think I've ever seen one with counsel. They're always pro per litigants.
Great. So then my next question, sort of based on that answer, is, we're making some pretty substantial changes in terms of the 21-day requirement of who has to be served, of the 7 calendar days versus 4 working days. Is the court involved in any way in letting potential plaintiffs know about these changes? Is that something that the Self-Help Center would be able to inform them? I'm just wondering about that aspect of how will folks know that we are potentially changing the law if they're perhaps used to how it used to read.
Yes, Chair Yeager, the Self-Help Center is always involved in all of our case types. So we do have forms that are provided. They do their best, honestly. On the form, we provide instructions. We try to give them guidance through all of those means, whether it's the Self-Help Center has, even during COVID, operated through email, through telephone calls, through virtual sessions with individuals with questions. So they're usually heavily involved. And I will say that because these are done on a court form, that form would, I don't know that it would require any changes to the current nature of the form. But if it did, the Self-Help Center would work with us to make those changes and make all of that readily available through their website. And the court's website has links to our Civil Law Self-Help Center. So we want to make sure that we never have conflicting information. What we do as the court and work with the Self-Help Center, we verify the information that they have on their website is accurate. And then we provide a link to that so that they could come to either place and get that same information.
Thank you for those responses. I have a few other questions so far. So we'll start with Assemblywoman Kasama, then I have Assemblyman Miller and Assemblywoman Cohen. So please go ahead, Assemblywoman Kasama.
Thank you, Chair, and thank you, Judge Zaragoza, for the presentation. My question to you is, I had a sense that the 7 calendar days might still be a little bit tight. And perhaps since we're changing the statutes anyway, maybe 10 calendar days, just a consideration to make it as reasonable as possible for the court.
It's not uncommon with the 4 judicial days now that we get to that hearing and the plaintiff vehicle owner has not had the opportunity to get the other side served. That's a very common scenario. It is a tight window. I think those are policy issues that I think this committee can discuss and address. The number of days. I mean, anything tighter, anything closer than 4, I think would be impossible to get notice. We certainly, it's just really quick. The only time the 7 calendar days might get to be tight would be on a holiday weekend or something like that, where the process servers and the constable's offices are closed. So it makes that window a little tighter, but I think those are all considerations for this committee, and I just offer my information and let you all make the policy.
I might suggest that we do 10 days. May I indulge the chair with one more question?
Yes, please.
So under section 1, that would be C, I believe, where it says the cost of towing and storing the vehicle does not exceed $15,000. I'm just curious where that number comes from, and if we set an amount in statute, does that need to be changed 10 years down the road, or how is that number arrived at?
Yes, that number, Assemblyman Kasama, is derived from NRS 4.370, which is the limited jurisdictional limit. So that $15,000 amount is our jurisdictional limit. And so I guess in this case, that that amount was originated, it always tracked that amount rather than the value of the vehicle. It tracked the amount of the towing and storage costs to keep in line with that. And I would note, I just noticed this as I was looking at this, as you pointed it out, paragraph 1C, I think there actually should be the for a vehicle that was towed should be stricken, and it should just read, the cost of towing and storing does not exceed $15,000. I think it's probably just a oversight. But that's how it's derived now.
Okay, great. Thank you so much.
Up next, we have Assemblyman Miller.
Thank you, Chair Yeager. Thank you, Judge Zaragoza, for the presentation. I have a couple of questions for you. One, just so that I'm clear, what we are looking to do with this bill is to remove the tow operators from the filing or the, I guess, initial complaint that is filed and put that totally on the owners. Is that correct? Of the property?
Assemblyman Miller, currently the way the statute reads, the tow company is not the proper defendant. Okay. They never have been the proper defendant. And this, my attempt in this bill is to just make that even clearer. The current language is always the owner of the property from which the vehicle was towed or immobilized. It's just not followed. It's confusing. And so I'm trying to clarify that. So the tow company's never been the proper defendant. And in regular course, when the tow company is named, we always have to continue the case, amend, reserve the right person. Now 4 or 5 more days have gone by. Now the vehicle owner suffers additional storage costs. So I'm trying to make it as clear as possible to give the expedited relief to the vehicle owner when it's appropriate as quickly as possible. So I'm not changing it. I'm just trying to make it more obvious, I guess.
Okay, I understand. Thank you. Chair, may I continue?
Yes, please.
Okay. So with that in mind, I can imagine that when vehicles are told that when a person goes to acquire their vehicle, that they're not necessarily being told of the quick remedy process in the event that they believe their vehicle was unlawfully towed. If in fact the vehicle was unlawfully towed, and I'm asking for your clarification on this, if the vehicle is in fact unlawfully towed, would that not also make the tow company responsible for acting on behalf of the owner in an unlawful act?
Assemblyman Miller, 2 parts to that question. In terms of, are they being told of the information? Currently existing in the statute and unamended by this bill is paragraph 7. And that is the facilities, the storage facilities, the tow facilities are required to conspicuously display all of the information that's in this statute. So whether or not that's being done, I couldn't say. I have not had the opportunity to go and inspect and see that that's there. I trust that it should be, but that is a mandate that's already in the statute and unaffected by this, other than they would have to amend their signage to comply with any amendment should this bill pass. The second part of that question was in terms of who's responsible, and that is part of what is not covered in this bill. So for example, if the vehicle was unlawfully towed and the court finds that it was unlawfully towed, then the order from the court would be to that tow company, you have to immediately release that vehicle to the vehicle owner, regardless of who's responsible for the storage and tow costs. It makes the property owner who directed that tow liable. And in the other statutes, 487, 037, and 038, the tow company can be contracted with, let's say, an apartment complex. That's a common scenario. So if the tow company has a contract with the apartment complex, they might be enforcing the apartment complex's rules and regulations regarding towing. So there is a relationship there, but the court's not getting involved in that contractual relationship at all in this particular kind of a case. We're not making a determination as to whose in terms responsible for any money damages in that case. We're simply directing the tow company. If it was unlawfully towed, then you have to release the vehicle immediately. That's the determination that we're making. And then the liability for the costs falls on the property owner who contracted with an agent, the tow company, to tow the vehicle. So there's a principal agent relationship there.
Okay, thank you. And just one last question, Chair. And this is on the time frame. So I understand that the time frame that we're looking to expand that time frame, but I guess my question would be if, and this kind of follows in line with what I was just asking, if the person whose car was towed essentially comes to the court and they name the tow company, and you say no, it's actually the owner. If we were able to allow the tow company to be incorporated in that, since they already have a contractual relationship wherein they are acting on behalf of the owner when they tow the car, could the tow company be served on behalf of the owner in the sense that it would actually result in an expedited recovery of the vehicle rather than a longer process? I guess my point there is that if it's supposed to be expedited, and when people whose vehicle, especially their main vehicle, has been towed unlawfully, they may not have 3 days, 7 days, or even 10 days to acquire it back. If it's been towed unlawfully, it could totally disrupt their lives. So I guess I'm trying to figure out if there is maybe another path where we can actually speed up the process rather than it results in more stays or an extended time in people recovering their vehicles.
Assemblyman Miller, understood your thought process there. I guess there's a couple of things I would comment on. One, the tow company would not be in a position unless there was some authorization to represent in the hearing a totally different entity. They can't practice law. The bottom line is they're not lawyers. They can't practice law. So they're really pro per litigants on their own. They come into court, they represent their own business, but that's the extent of what they're generally authorized to do. And it's interesting, this particular bill doesn't even really address that in a similar fashion. Just compare and contrast that to our small claims statutes. Our small claims statutes have a specific provision that allows an LLC or a corporation or a partnership or otherwise to be represented by one of its officers or directors. This particular section doesn't have that. Yet in practice, I will tell you that we never have lawyers really on either side. That's very uncommon. I shouldn't say never, but it's rare. Instead, you have someone from a property management company who's in a similar position. They're not the property owner, but they might be named as the defendant, and they're just the management company, but they are an agent for the owner of the property. The tow company is in that similar position. And if there was some authorization for the tow company, who is the person most knowledgeable, to come in, to be served and to come in on behalf of the property owner, I think that would be a decision that this committee could make. From my perspective, from the court, I don't have any real issue with that. What I want are the facts. I want to know what happened. I want to know why the vehicle was towed, whether it was stickered, when it was towed, who authorized the tow. Those are my questions in the court hearing. And in general, you're correct. The tow company has that information, yet the way the statutes are written currently in 487, 037, and 038, the tow company is not the person authorized to make that determination. It's the property owner who has to direct and authorize the tow. So I'd be totally willing to communicate further with this committee on any things that you'd like to see and kind of massage some language that you think would accomplish something being done quicker and easier. That was kind of my goal, is to make it really clear in the statute. And then maybe that signage, the conspicuous signage, would make that clear, because it is deceiving. I shouldn't say deceiving. It's just confusing for the vehicle owner. They're like, my car was towed. I want to sue the tow company. That's what they think. And so I'm trying to clarify that.
Thank you very much. I would love to work with you on that and see if there are some maybe amendments that we can present to the committee for suggestion. Thank you so much, Chair. Thank you, Judge Zaragoza.
Let's go next to Assemblywoman Cohen.
Thank you, Chair, and thank you, Judge. My question is about the new paragraph 6, and I appreciate that the tow company is a bit of a bind, because someone's coming in and saying I have an order, but they're not presenting a certified order. But you know, that paragraph kind of struck my interest the first time I was reading through it, because I think back over the last several months, and as an attorney, and also in communication with other attorneys, we were having trouble getting certified copies, not from the Justice Court, from the District Court. But I mean, we've got pro-pers who may or may not have other transportation, and now we're asking them to get a certified copy, which can be difficult at times. So is there anything we can do to make that process easier for them? Are they able to leave the courtroom with a order that they can then walk to the clerk's office to get certified? And if so, are they made aware of that? Can you just give me a little more information about that, the way that pro-pers in Justice Court get certified copies?
Assemblywoman Cohen, thank you. That's a good question, and you're 100% right. COVID times are different than regular times, and I guess it has been a little more challenging in the District Court. Obviously, the Justice Court is kind of more of the people's court. We have so many litigants who are pro-per, representing themselves. They don't have the technological means to do a virtual hearing. So almost all of these kinds of cases, even though we offer virtual sessions, they're coming in person. And yes, they leave the Las Vegas Justice Court, or they could leave the Las Vegas Justice Court. Since the requirement's not there now, we just hand them a regular copy. But they walk out with an order. We have an order already, a kind of a form order that I would, kind of check the box, fill out the information, determine the cost of towing and storage, those kinds of things. And I just handwrite it in on the bench. It's very easy. They walk out within 5 minutes of the hearing or less with a copy, and they could easily walk out with a certified copy from my court. I can't speak for other courts in the state, but I can say in my conversations about this bill with the Nevada judges of limited jurisdiction that most of our other jurisdictions don't see a lot of these, given the volume of our cases in Las Vegas Justice Court. I think we see the majority of them. So I can't speak for others, but we would hand it right to them in court. Now, if they're making a virtual appearance, that might be a little more difficult. We might have to come up with a different resolution where we can electronically certify it. I believe we have that capability here, and then electronically send it to them so that they have it.
Okay, thank you.
Are there other questions for Judge Zaragoza from committee members? I don't see any. Judge, I had a very quick question to get your legislative intent on the record. If we look at, I guess it's page 2 of the bill, but it's section 1. If you go down to line 26, which references that the filing must be within 21 days, I just wanted to ask if you wanted that to be judicial or calendar days, because I think the absence of the word calendar means that it would be judicial.
I don't, as Chair Yeager, I don't know that it would by absence be judicial, because the court rules, even the Justice Court rules, say anything under 10 is judicial and over 10 is calendar. But it would be my intent to be calendar. And like I said, that 21 number was selected kind of to ensure that the remedies that were, the expedited remedies that were available would still be available by the time we set a hearing on it. Whether that would be, 28 days or 30 days or, 18 days, whatever this committee thought, if you thought something alternative, the number of days is less significant, I think, for the court, than there has to be some limit. Because if we have these cases get filed and rush to set a hearing, and yet the vehicle was towed 4 months ago, which I see, it's months. People wait months to file these cases. That vehicle is long gone, and I can't provide them the relief that they're seeking in this expedited fashion. They always have the right to go with that civil remedy. But it would be my intent to be a calendar day. I just think across the board, that's the direction that the state has been moving, is to increase the number of days and make it calendar rather than this judicial day idea. And then the court rules would say it's always extended to the next business day if it falls on a Sunday or a weekend or a holiday.
Thank you. I'll make a note of that. If we do end up amending this bill in some fashion, I think we can just put calendar in there to clarify any potential confusion.
That would be great.
Last call for questions for Judge Zaragoza. Okay, I don't see questions. So, Judge, I want to thank you for presenting. We'll ask you to sit tight for just a moment, and you'll have a chance for some concluding remarks after we take testimony. At this time, I'm going to open it up for testimony in support of Assembly Bill 32. We do have Mr. Segura on the Zoom with us. I think he was having some video trouble, so I think he's actually on the phone, but he is in the Zoom room. So, sir, if you would like to go ahead and unmute and provide testimony in support of Assembly Bill 32, please go ahead and do so at this time.
Hello, my name is Robert Segura, Robert Segura. I represent the towing industry. I specifically am the general manager and partner in 3 of currently 62 non-consent tow companies. We account for about 40% of all of the non-consent impounds in the Clark County and Southern Nevada region. A couple of points. I'm in complete support of Judge Zaragoza's proposal. The 21-day scenario definitely works in the standard process of lien processing, where we obtain ownership of a vehicle in order to recoup fees or to have an exit strategy on the vehicles that are towed. That standard process is 45 to a 75-day window, hypothetically. So the 21-day fits perfectly in our scenario versus now where it's just kind of based on when people make a decision to file or not file. In terms of the cost, the time, the money, the repeat visits, it's unfair to the holding party as far as the tow car operator, as well as the complainant or the plaintiff, because nothing's going to be resolved or satisfied until all parties are present and that the judge has the ability to hear all evidence and to make a fair and equitable ruling for both parties that are involved, whether it be the owner agent of the property or the plaintiff. Judge Zaragoza spoke very directly and correctly in terms of the process. We are dismissed from all cases as defendants, generally within the first 5 to 7 minutes of all cases. Question was asked by Chair Yeager as far as numbers. Specific numbers, 99% of the cases are pro per capacity. Very rarely you'll see an attorney involved for either party. I personally represented 67 cases in 2019. In 2020, I represented 39 cases, and that was shortened obviously due to COVID. And then thus far in 2021, 7 cases and 1 tomorrow at 1 o'clock in Department 5. So that will put me at 8. That's just kind of an idea of what we're looking at. And again, I account my companies for 40% of the impounds in the Southern Nevada region. So all in all, Assembly Miller also had brought up a question as far as requirements. On the bottom of all of our invoices, as required by the Nevada Transportation Authority, which is the actual body, governmentally speaking, that regulates our efforts, it's stated on every invoice that we produce that if you have any questions concerning the services provided, or if you wish to file a commendation or complaint, you may contact the Nevada Transportation Authority at their phone number or through its website with a listing of the website. Also, as Judge Zaragoza alluded to, conspicuously posted and also available with our tariff rates as a requirement to do business as a tow car operator are also remedies and other avenues in terms of taking it to court or providing some sort of a civil matter in regards to the situation. Unfortunately, we try to educate the public one customer at a time as to what the best case scenario is. We recommend they get the vehicle out immediately to lower the costs and effect on them financially. And if they're not satisfied with what we are explaining to them, they can take us to court. They have remedies with the Transportation Authority. So we try to provide them the avenues because it's inevitable that it's going to take place. I can't speak for all tow car operators. I can only speak for my companies. And I've been in the business for 34 years, so it's something that I've dictated and have spoken with other tow car operators, and all the things that have been mentioned and proposed with AB 32 are definitely items that the tow companies would be in support of, because it really just saves time, it saves effort, and it allows things to be heard quickly, and with all the different restrictions and caveats, involved with COVID-19 and just access and obtaining resolutions within the court status. In structure, it's just a lot easier to knock it all out at one fell swoop. I can speak for us specifically. We would not be adverse to being named, not necessarily liable because we're acting as the agent for the owner or agent of the property, but we would have no problem being required to attend the court cases because, as Judge Saragosa and I believe Assemblyman Kasama pointed out, we have the majority of the times all of the evidence or all of the necessary paperwork or documentation that would be required for a fair judgment to be made. And that's all I have to contribute at this point, or I can answer any questions if anybody has any.
Thank you so much for your testimony, Mr. Segura. We appreciate it. At this time, seeing no additional comments from folks on the Zoom, BPS, I'd like to go to the phone line to see if we have individuals there who'd like to testify in support. I see a few people have signed up in support, so let's go to the phone and see if they're there and ready to provide testimony.
Thank you, Chair. To testify in support of Bill AB 32, press *9 now to take your place in the queue. Would the caller with the last three digits of 828 please slowly state and then spell your name for the record? You will have 2 minutes and may begin. Caller with the last three digits of 828, press *6 to unmute yourself, and you may begin your testimony.
Sophia, Sophia, Romero, Romero. Good morning, Chairman Yeager, Vice Chair, members of the committee. For the record, my name is Sophia Romero, and I am an attorney at Legal Aid Center of Southern Nevada. First and foremost, I want to thank Judge Saragosa for bringing this bill. AB 32 solves several problems that we see on a regular basis, and as such, we are in support of this statute, proposed statute, excuse me. As far as we're concerned, the 7 days to set the time as the time frame for the hearing strikes a good balance. You have to remember that these people are up against the clock. They're trying to prevent their vehicles from having a tow lien put on them and be sold. So the faster that we can get a hearing that we don't have to continue because there was not enough time to get somebody served, is better for the actual, the owners of the vehicle. And so we think that the 7 days does strike a good balance with that. So I think that thinking was absolutely correct, that is enough time to get somebody served and also quickly enough for a turnaround time for a hearing in order to help people get their vehicles back more quickly. We also agree that the entity who is the proper defendant has been laid out in the statute correctly. It is the owner of the property who authorized the tow, who would be the proper defendant in these according to current statute. And, they have the information on what was the cause of the tow. Why did they call the tow company out to come and tow that vehicle? As far as everything else, again, we are fully in support, and we just want to thank you for your time today and to thank Judge Saragosa for bringing this bill.
Thank you for your testimony, Ms. Romero. BPS, could we see if there are other callers in support?
Would the caller with the last three digits of 580 please slowly state and spell your name for the record? You will have 2 minutes and may begin.
Good morning, Chair Yeager. I'm Paul Enos, E-N-O-S. I am the CEO of the Nevada Trucking Association. We have a little over 36 tow car members, and we're here today to speak in support of AB 32. Right now, the current process to file a complaint against a towing company goes to the Nevada Transportation Authority. They only regulate the tow operator. They don't regulate the owner of the real property who requested that tow. I will say, in looking at the bill, it does mandate that you file against both the owner of the real property and the tow operator, the tow company which towed the vehicle. So it's not like the tow companies are not going to be a party to this suit. They still will be. We do think there is a value in having Justice Court bring a quicker resolution of the process by having all parties involved in the tow. So we are supporting Assembly Bill 32. Thank you.
Thank you for your testimony, Mr. Enos. We don't normally have you in Judiciary, so it was nice to hear from you on this bill. BPS, is there anybody else in support?
Yes, Chair, there is. Would the caller with the last three digits of 911 please slowly state and spell your name for the record? You will have 2 minutes and may begin.
Good morning, Chair Yeager and members of the Judiciary Committee. My name is Maggie O'Flaherty, Maggie, O apostrophe, F as in Frank, Laherty, here this morning on behalf of the tow operators of Northern Nevada, TON for short. Thank you to the committee and Judge Zaragoza for bringing AB 32 forward. TON is here in support of the legislation. This bill provides for the inclusion of all relevant parties, including the property owner or their authorized agent, to be involved in actions regarding the lawfulness of vehicle tows in Justice Court. And having the property owner be a party to these proceedings is critical on our end because, as Judge Zaragoza indicated, in most cases, the tow operator is acting at the behest of the property owner and only has access to certain facts and sometimes history regarding the tow that the tow operator themselves may not otherwise have. And given this, their inclusion in the proceedings will help minimize room for error and ensure proper outcomes come out of the courts. So again, thank you to Judge Zaragoza and the committee for bringing the bill, and we are happy to offer our support. Thank you.
Thank you for your testimony, Ms. O'Flaherty. BPS, anybody else in support?
To testify in support of Bill AB 32, press star 9 now to take your place in the queue. Chair, there are no more callers in support of Bill AB 32.
Thank you so much. I will close supportive testimony. I will now open opposition testimony. There is not anybody on the Zoom in opposition. BPS, could we check the phones to see if there's anyone there in opposition?
Yes, we can. To testify in opposition of Bill AB 32, press star 9 now to take your place in the queue. Chair, there are no callers in opposition of Bill AB 32.
Thank you, BPS. I'll close opposition testimony. I will now open neutral testimony. There isn't anybody on the Zoom in neutral. BPS, could we check the phone to see if there's somebody there?
To testify in the neutral position of Bill AB 32, press star 9 now to take your place in the queue. Chair, there are no callers in the neutral position.
Thank you so much, BPS, for helping us through that. I will close neutral testimony, and at this time, I'll hand it back over to Judge Zaragoza for any concluding remarks on Assembly Bill 32.
Thank you, Chair Yeager. I did realize as I was listening to the others talking that maybe I confused something, and this might help in response to Assemblyman Miller's concerns as well. So currently, even though it's not in the statute, the litigants oftentimes only name the tow company. And what we end up doing is, as Mr. Segura stated, is dismissing them from the case because they're not the proper party, but requiring that property owner to be brought in. And what I was trying to do in paragraph 2 of this bill was identify the proper defendants, but it was made clear, and I'll make it even clearer now, that what we want is all the proper parties brought, not just the property owner. We want them to continue to name the tow company as the relevant party with as the most knowledgeable person to be in court and be served. And if you read in paragraph 2B, 1 and 2, it must be filed against the owner of the real property and the tow company which towed the vehicle. And so the tow company would naturally be a part of that process. And then when you look at paragraph 4, they would be a person identified in those subparagraphs would have to be served. So both entities would be served and hopefully get everybody together at the right time. The other important aspect of that is without the tow company involved at all, we wouldn't have the facts that we need in the court to make a determination. 1, 2, because this is in the nature of a declaratory relief kind of issue, and we are going to be entering an order potentially for a tow company to immediately release the vehicle to a litigant, to a vehicle owner, in either a circumstances that they pay or immediately because it was unlawfully towed. We're now issuing a court order in the way of an injunction almost against a tow company. If they're not named in the complaint from that beginning point, it makes it a very awkward situation. The court would be put in a position to enter an order against a non-party without giving them an opportunity to be heard. And that would be a due process violation. So I hope I didn't confuse things too much in my initial testimony. And I can see Assemblyman Miller is reacting in a manner that I probably did confuse things, and I'm so sorry. And I hope that clarified it, that it was the effort to bring everybody together. So I apologize for misleading or being confusing earlier.
No, that's totally fine. It's been a long morning, so I think some of us missed that in the text as well. Judge Zaragoza, any other remarks before we close the hearing?
None, thank you.
Thank you so much for joining us this morning, and thank you again for your patience as we got through the other bill on the agenda. We appreciate you being here and hope you have a great rest of the day.
Thank you, you too.
So I'll close the hearing on Assembly Bill 32. That'll take us to our final item on the agenda, which is public comment. By way of reminder, we reserve 30 minutes for public comment at the end of each meeting. Callers will have up to 2 minutes to provide public comment. Public comment is a time for matters of a general nature that fall within the jurisdiction of the Assembly Judiciary Committee. It is not a time to rehash hearings of bills that we have already heard or may hear in the future. So with that behind us, BPS, could we go to the public comment line and see if there's anyone there who would like to give public comment this morning?
To provide public comment, press star 9 now to take your place in the queue. Would the caller with the last 3 digits of 037 please slowly state and spell your name for the record? You will have 2 minutes and may begin now.
Tanya Brown, TONJA, BROWN, Advocates for the Inmates and the Innocent. Good morning, Chairman Yeager and members of the Judiciary. I just want to state for the record, okay, because you know we're all doing this from home now. I have a lot of distractions, particularly named Sadie, who is about 100 pounds raw, Sadie, and Oliver, who is about a 9.5 pound Shih Tzu. And it's like they're like having children, and you have to keep one eye on them at all times. If you saw what went on and what goes on in this house in the early mornings, you would find it quite entertaining. I, on the other hand, find it a distraction, especially when I'm speaking to you or other committee members. So I just kind of wanted to put it on the record that sometimes I get distracted when I'm speaking because I don't know when a feral cat is going to walk into the yard or when construction workers are going to come and start working on the house next door. So you don't know whether the dogs are going to bark, cry, run through the house, or when they do their zoomies. So I just want to put that on the record that they can be quite a distraction for me. So if I come off like confused, you'll know why. But I'm thinking that pretty much everyone has little issues like this. It's like I said, having little children in the house, and you have to keep one eye on these guys at all times. That's all I wanted to say. Thank you and have a great day.
Thank you for your public comment, Ms. Brown. BPS, is there anybody else on the public comment line?
Yes, Chair. With a caller with the last three digits of 556, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Anne Marie Grant, ANNEMARIE GRANT. My brother Thomas Purdy was killed by Reno police in Washoe County Sheriff's Office, October 8th, 2015, during a mental health crisis. Today I'd like to read you a letter from the mother of 25-year-old Jorge Antonio Gomez, who was killed by Las Vegas Metro June 1st while he was out protesting for families like myself, for families like George Floyd, who had lost a loved one to police, and sadly he became a victim. My son was killed by Las Vegas Police Department on June 1st, 2020. He was on his way to his car to pick up his dad from work, which was around the corner from the federal building. He was walking on a public sidewalk and police officers began to speak with him, and so he slowed down. One officer then came down at him and shot at him with low lethal rounds. He ran and 4 other officers, seeing him running, shot him 19 times. These are the facts. The police changed their story multiple times to why no body cams and that the officers aren't required to have them due to budgeting issues or their job title. Nevada law requires them, period. Over 30 cameras in the area and LVMPD refused to release the videos. Jorge Antonio was such a kind young man that felt the injustice, as we all do, and wanted to be there in support of the BLM movement and exercise our First and Second Amendment rights. He was never aggressive and is seen on various videos peacefully protesting. Not that it matters, but he had no criminal history. He are not anti-police. He are anti-corrupt cops and those who aid them. We are a military, canine officer, Homeland Security family. What we will not accept is this ridiculous portrayal of a great human being that the world lost on June 1st, 2020. Jorge Antonio was a kind soul. He loved animals. He helped the homeless. He loved the music and our earth. He cared for everything and just wanted to make it better and a safer place to live. We will not rest until we find the whole truth. No justice, no peace. Thank you.
Thank you for your public comment, Ms. Grant. BPS, anybody else on the line for public comment?
To make public comment, press *9 now to take your place in the queue. Chair, the public line is open and working, and there are no more callers at this time.
Thank you so much, BPS. As always, appreciate your hard work in making these meetings happen. I will close public comment. Anything else from committee members this morning before we talk about the rest of the week? I don't see anything. I want to thank you all, and it was a long morning, and that bills took a little while today, but appreciate your time and attention and questions. And please, on the first bill in particular, if you didn't have a chance to ask your question, do seek out Assemblyman Flores. I know he'd be happy to answer any questions you have about his bill. In terms of the rest of the week, tomorrow we have one bill. We're going to start at 8 o'clock because that bill may take us a while. And then we do have an agenda out for Thursday that I think just was posted while we were in this meeting. So we have 2 bills scheduled for Thursday. And again, that will be an 8 o'clock start. Friday, we're potentially looking at doing a work session, trying to get that solidified. And I'm not yet sure about bills. We're going to see what we potentially get on the floor today. So we are going to have a meeting Friday, just don't know what's going to be on the agenda and what time it's going to be. And then I don't have any information for you yet about next week. Hopefully will by the end of this week. So with that behind us, thank you all. It's a pleasure to chair this committee. It's a pleasure seeing you all every morning, bright and early. And I will see you all back in this committee tomorrow morning at 8 a.m. This meeting is adjourned.
Thank you, Chair.
Goodbye.